Weekly list item number 1.
May I please illustrate? In this case, petitioner's minor girl has been kidnapped since 10th August 2023. Thereafter, the clue has been provided to the police that the kidnapper is talking with the father of his father and regularly, and he has kidnapped the guy, and the detection location has also been produced before the police. The police has not taken steps. Thereafter, subsequent FIR has been made as they are threatening to withdraw the case and disclose before the police. The girl voluntarily left the house. That has been also registered, but no action has been taken for recovery of the girl. The annexer page 16 minute this was last affair where the father of the kidnapper compelled the petitioner to write before the police that she left the house voluntarily.
What is the date of birth of the
I have filed the
36
certificate.
2006? 36 2006. 6. It is 17 years. 17 years. What that boy was doing?
For general, well, not engaged anywhere.
Hmm?
Not engaged after reading
That co-villager.
on other villager.
Okay. What your daughter was doing?
She, at the time she is reading mallet.
So it's coming for the first time. Certain instruction. Instruction. All right. This writ application in the nature of habeas corpus has been filed with a prayer to rescue the minor daughter of the petitioner, who is stated to be in unlawful custody of opposite party number 4, Biswaranjan Mahanti. The petitioner is the father of the victim, and he lost the first information report on 10/8/2023 before the inspector in charge of Bhadrak Town Police Station, on the basis of which Bhadrak Town PS case number 419 of 2023 was registered under section 363 of the Indian Penal Code against the opposite party number 4. The land counsel for the petitioner submitted that even though in the meantime 5 months have already passed, more than 5 months have already passed, but the investigating agency has not taken any sincere step either to rescue the victim girl or to arrest the FIR named accused. Even though some clue has been provided by the petitioner regarding the whereabouts of the opposite party number 4, Subparal and counsel for the state seeks some time to obtain instruction in the matter. Put up this matter. Put up this matter in the week commencing from 19th of February 2024. The land counsel for the state shall obtain instruction, produce the case diary. So also an affidavit is to be filed by the investigating officer, public IIC, regarding steps taken by the for rescue of the victim girl and for arrest of the opposite party number 4. Free copy of the order be handed over to the Land Council. Yes.
Item 2.
May please, Your Lordship. Here the petitioner is the father, Your Lordship, has filed this petition in habeas corpus, Your Lordship, for rescue of her minor daughter, who was pursuing her studies +2, Your Lordship, in Khoira College. And while she was in vacation, um, she was abducted by the opposite party number 4, Your Lordship. To that regard, Your Lordship, the petitioner had also approached the SP, Your Lordship, but as yet no steps has been taken for recovery of the minor daughter, Your Lordship.
What is the date of birth of the victim?
Date of birth, Your Lordship, 15/7/2006, Your Lordship. Annexure 1 is the
So it is
Board of Secondary Education Certificate.
17. So it's a fresh matter. You obtain instructions so that देखिए कि लिख दो सही type का order करेगी. खाली in addition to that लिख दो. It is stated that representation has been made to the superintendent of police, but no fruitful result has come out. है ना? बाकी सब लिखीं तब उसी होंगे. ऐसा providing tutor और बुनियाद है ना? So that is to be. So same date 19/2 case diary to be produced. Yes.
And affidavit to be filed.
All the
Right.
that order will be remain, but only that. Yes.
Item 3.
My lord, victim minor daughter of the petitioner was kidnapped by the OP number 5 and dated 25/4/2023, and FIR has been lodged under section 363 IPC. But till
In
that,
the FIR, you have named that person,
in the name that
and he is now the opposite party number.
number 5. 5 is the kidnapper, and he is being encouraged by the opposite party number 6 to 10.
Who are the 6 and 7?
Their parent is related.
Parents, and one is the parents' brother, Dada Tara,
No, you have
and
made
some local people also. That is Subodh Kumar Lanka, who threatened her mother, petitioner latter. On this, there is also an FIR lodged against Subodh Kumar Lanka.
your FIR is only one person.
One person.
That is the main accused.
Yes.
So why have you implicated so many persons in the FIR?
Because
The
they
writ
are
petition.
threatening that petitioner, and there is also another FIR lodged against the one Subodh Kumar Lanka, and all others are the relatives.
What is the date of birth of your daughter?
5/9/2009, my lord.
9 means it is 14. 14.
Whenever exactly she was 13, she was been.
She was reading in school.
Yes, he's continuing in class 9.
And what the boy was doing?
Boy is 28 years old, and he was a Janaseva Kendra. He was running a Janaseva Kendra, I think.
Same village.
Same village.
And you have also represented before the SP and
SP Kendra,
okay.
and also SDPO.
This lady is the mother of that church.
Yes, mother of that.
So take down in the same manner, but here it would be opposite party number 5. Okay. Baki representation has been made to opposite party number 3 SP Kendrapada and SDPO Marsagai police station. है ना? बाकी सब समान रहेगा. So matter will come on 19th. We copy. Yes.
Item 4.
May I please, your lordships? My lord, this is a writ petition with a prayer for the production of the son of the present petitioner, my lord. The present petitioner is the mother of the minor son, who is 7 years old. He was taken from the custody of the mother on 15th December 2021, your lordships. Actually, the father took the kidnapped the child, but problem is that the child is not with the father now.
No. Who
And-
is the opposite party number 5?
Father of the son, my lord.
So you are the mother
Yes, my lord.
when your marriage took place.
2012, my lord.
2012.
Yes, my
Is there any other proceeding in any court? Family court?
yes, my lord. The divorce proceeding is going on.
So if the divorce has not yet been completed, why have you not mentioned that you are the wife of opposite party number 5? Why are you mentioning that you are daughter of Umakant Naik?
But my lord, in the petition, I have mentioned that I am married to.
No. What is the harm in mentioning that you are the wife of opposite party number 5?
No harm, my lord.
Divorce
But
proceeding is still pending.
yes, my
Still,
lord.
he is your husband.
Yes, my lord.
You are the wife of opposite party number, and you are reluctant even to mention in your petition that you are the wife of opposite party number 5. Number 2, if the child is in custody of the father, how it can be a case of
Absolutely,
illegal
my lord.
detention?
The father has every right, and he is the guardian also. But problem is that I have gone to the house also to meet my son, but the son is not there. He told that he is in some other relative's home, and he is not pursuing his studies also. So I apprehend that he is not
What
in
is
a
the age of your son?
7 years, my lord. Though I have not produced any document regarding that, I
So it's
can.
all right. We believe your statement, but your son is not reading in any school now.
Right now, the present the school he was reading, now he is not going to that school, so I don't have any idea whether he is reading or not, because I have not seen him from 2021, and as I have lost an affair also, the which is in Annex
Since
1.
when your son is living in with his father?
No, my lord, he is not, now he is not living with his father.
It's already since when that child has been separated from you?
My lord, on 15th December 2021.
21. You
Yes,
have
my
not
lord.
met your child since then.
No, my lord.
But since you have, who has approached the family court, you or your husband, for divorce?
Certainly, I have to take instruction about that, my lord.
And how many criminal cases you have instituted or any other proceeding?
Let the matter be fixed to some other day. I will take the instruction about that. I have no instruction about her marital dispute, my
Get
lord.
that instruction. And
Yes, ma'am.
you have, when your family court it is pending, then appropriate proceeding can be initiated if you claim guardianship of that child.
Absolutely,
You
my lord.
see
But
that the scope of this habeas corpus is very limited. A child is remaining with his father, and let us say tomorrow he will come and say that I am living happily with my father. There is no problem. Then the other things which are required to be done, that in whose company the best interest of the child would be served, that is to be adjudicated by taking evidence that cannot be done here in this WPCRL.
absolutely, my lord. But the production of the child can clarify all the doubts also.
But you take instruction, we are keeping it to, this is in the weekly list. We can
Yes,
take up this matter if you so like, it can be taken up tomorrow or day after tomorrow, but take instruction. How many
yes,
cases you have instituted or your husband has instituted against you?
yes, my lords. I
So when do you want, tomorrow or day after tomorrow?
day after tomorrow will be better.
Okay. Call this matter. Let it come on day after tomorrow.
Wednesday.
7th.
God bless you.
Item 5.
Your mind of the father's application for custody of the son is neighbor. On the ground that the wife of the petitioner has married for the second time, and the son is in illegal custody of opposite part number 4 and 5, who are the maternal grandfather and grandmother. I have also included the second husband as opposite part of
No, who are you?
I am the father now of the minor.
Okay. And who are these two persons? This video 6 is
4, 5, they are the mother-in-law and father-in-law of the petitioner.
okay. And your wife
And
is
the wife has married for the second time. I have made the second husband as opposite part number 7.
6 is the
While
6 is this.
substance of the marriage, he
Okay.
married to opposite part number 7.
No divorce is there.
No,
What is the age of that child?
11 years.
11 minor.
12 years.
12 10 वर्ष 11 वर्ष होला
12 वर्ष तो
okay. So serve extra copy of the petition. Let notice be served on this 4 person and you take instruction. Okay. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. This WPCRL has been filed by the petitioner who is the father of the child with a prayer for production of his son who is stated to be in illegal custody of opposite party number 4 and 5. It is stated by Ms. Mahapatra that the petitioner married to opposite party number 6, Babita Meher, and the son was born out of their wedlock. And on account of dissension, the opposite party number 6 left the company of the petitioner. And even though there is no divorce between them, she married the opposite party number 7, and the child of the petitioner and the opposite party number 6 is now staying with the opposite party number 4 and 5, who are the grandparents of the child. Baki, है ना? And child has been illegally confined for them. Issue notice also. Let 4 extra copies of the writ petition be served on the land council for the state, which will be sent to Loisinga, IIC Loisinga police station for its service. No, this is Loisinga police station, so also to Patnagar police station for its service on OP number 4 and 5 and 6 and 7. Matter be placed in the commencing from 19th of February 2024. The Land Council for the state shall obtain instruction in the matter. Yes, 3 copies.
my lord, in this the extra copy, let the ISU serve notice on them,
Right.
and they'll when they will appear, my lord, let them serve copies to them.
We have fixed the date
My
is 19th.
My lord.
So you are just to cut short the delay. We are adopting this method
Because
that take the
there are
notice.
four,
from the-
four parties there. The notice will, because in that way will be immediately sent through WhatsApp and mail only the notices. So
Okay.
he will serve on the opposite parties.
So we are not mentioning 4 extra copies.
Exactly.
You or let's say 4 extra copies kati diyandu. The Land Council for the state shall send the 2 copies.
IAC will serve the notice on the opposite
IIC
parties to
will
appear
serve
before
this
the
also on opposite party number 4 and 5. Then IIC of that is nice, right? Of Patnagar police station shall serve notice on opposite party number 6 and 7. The date is posted to so and so. Okay, yes.
It will be on 19 May.
No, that 19th is the date.
May.
Item 6.
Please, Your Lordship. In this writ application,
A minute, just a minute. so far as
All the other
my
cases we
knowledge
can
of-
do that. Extra copy
they
not
scan it and
we are sending it.
concerned department with
Some-
a mail ID,
my lord.
password.
My lord.
The officer can access.
Because in all the police, actually in the police stations, my lord, all the emails they are not activated in there. They are not getting the email through us. So we are sending it through WhatsApp itself.
Okay.
So they are getting it and they are solving it.
No, that's good. But
It is in two way we are sending it through our messengers
Mhm.
and through our WhatsApp also we are sending it. So in immediate case,
well, mail facility is not there.
some police stations are not.
Otherwise, if
In
normal
remote
process-
areas, they due to network
because
problems.
if the private party normal process this type of matter
Yes.
would go, then obviously 4 weeks time will be
Yes, yes.
granted all the.
My-
Even if we said that speed post required,
Yes, yes, ma'am.
then all these things will delay the process. So that's good. All right, take.
Item 6.
May I please your lordship? I am the father of the minor child who has been kidnapped since 17/12/2023. And in that regard, I have reported the matter before the IIC quarterly. Later on the next day, we learned that the opposite party number 4 has taken away my child and kept now in Bolangir. And in
FIR
that
was
regard,
as a missing.
Okay, FIR is against unknown. So
unknown.
have you provided the name of that boy or who
My
has
lord,
taken?
my
You
lord,
added in the party.
my lord,
Here they have
representation-
added.
Okay. No, you have added is all right, but is it now known to the police that about the name of that boy?
my lord, we have informed the police, but no action has been taken.
No, that's all right, sir.
The past time.
So after the lodging of the first information report, you
Right.
have communicated to the investigating agency about the
lord.
name of this opposite party number 4
My lord,
who allegedly kidnapped your minor daughter.
my lord. And
What is the,
that
by the
time
way, what is the age of your daughter? What is the date of birth?
date of birth, my lord, 26/2/2007.
70 वर्ष के age.
17 years.
Yes, you take instruction, Mr. Mehra. Hard Mr. S.P. Mahapatra, hearing to the High Court Varga. This writ petition in the nature of habeas corpus has been filed for rescue of the minor daughter of the petitioner. Mr. Mahapatra submits that first information report was lost on 18/12/2023 by the petitioner before the inspector in charge of Bhatli police station, and accordingly Bhatli PS case number 301 dated 18/12/2023 was registered under section 363 of the Indian Penal Code against unknown person. But subsequently, the petitioner came to know that the opposite party number 4, Kaustuba Biswal, is involved in the case, and he has kidnapped the minor daughter of the petitioner, and accordingly due intimation has been given not only to the investigating agency but also to the superintendent of police Bargar. But no sincere steps have been taken for rescue of the minor daughter and to arrest the opposite party number 4. बाकी से type of डकाई usual order कर देवे, है ना? It is to come on 19th of February 2024. The free copy of the order be handed over. Yes.
Item 7.
It's a bail application. No, it's all right. You have filed a bail application and pay an interim application. What is the order, last order? Oh, it is not coming for the first time. Why you have filed an application for interim bail, on what ground? Your niece, you mentioned that Ankita Dole in paragraph 3 is suffering from some ailment, and for that huge expenses. You are in judicial custody since 7/10/2005. Okay, 18 years of past. How many times your bail application was earlier rejected, or you are granted interim bail by this court? Okay, you are granted interim bail for 3 months in by the order dated 16/4/2021 has been so the order ta dekhile 16 kebe kouchanti, right? So he was granted interim bail. So any kind of misutilization of liberty during that period? No, it was not. We granted him bail by the order dated 16/4/21, right? And that was a period for 3 months. And we also mentioned in that order that IIC Lalbagh Police Station shall keep a close watch on the conduct of the petitioner during the interim bail period and submit a report in that respect. So, 2021, madam. Right. So, has that IAC submitted any report to you? No. So take instruction about that, and because just paper book has not been prepared, and he is almost in custody for 18 years. 2005 he was taken into custody, not released on bail during trial, and released on bail by this court. For that 3 months, we do not know how many times he has been granted further interim bail. So get that instruction. We'll take up this matter next week. Okay. Yeah. It appears that the order bar kale jota bail itla IA number so and so, this is an application for bail 686 of 2022. It appears that the petitioner was granted interim bail for a period of 3 months as per order dated 16/4/2021 in IA number 125 of 2020. And the inspector in charge of Lalbagh Police Station was directed to keep close watch on the conduct of the petitioner during the interim bail period and submit a report in that respect to the Land Council for the state. After completion of interim bail period, the petitioner surrendered before the trial court. The Land Council for the state submitted that he has not received any report from the IIC Lalbagh Police Station as per the order dated 16/4/2021, and he may be given some time to obtain instruction in the matter, particularly with respect to the conduct of the petitioner while on interim bail. Court of this matter in the week commencing from 12th February 2024. Yes.
19 Mailer.
12 तारीख रखुଛି ଲାଲବାଗ ଥାନାକୁ ଆସିବ।
ଆଜ୍ଞା।
Number 8.
This should be placed with you how it are connected CRL. Yes, item number 8. Twenty-four 124. कोडी कहले कौन है ना पेज 3 रे हाँ ठीक है को जगह कौन है the matter was taken up by this court on various dates, right? Just a minute. ओहो एटा मिनती टुडू ही जाई कोन हबो मालती दियन दियन पे नाली पेन को आईए नंबर
Certified copy टा अछि
हां सेटा करेक्शन कर देंगे
रिटर्न करू
नाली पेन दिया नंबर 6 एटा स्कोर आउट कर आवाज एन ए लिखी दे बेटा carried out in court and certified copy according to the बस yeah I disposed of certified copy टा रखी दाओ correction करी देनी लेखियो आज for order dated so and so corrected yeah
Item 9.
May I please to your lordship? Your lordship, this is the bail application of appellant number 4, Rega Chatar, who is inside the jail custody for more than 12 years. My lord, the present appellant has been arrested and forwarded to the London court below.
just a minute 2013 matters are not assigned to the एटी कहीं आसची जे 2000 हमर पर 2010 पर्यंत थिला 10 minutes of SCJ ओहो आगु रिजेक्ट कर
My lord, earlier disposed of by your lordship and co-accused bail granted by.
let us see that okay yes sir. That is the reason. So you have filed IN number 3072 बाहर करो
Yes, my lord.
since when you are in custody
My lord, 12/12/2011.
you have never been released on interim bail
No, my lord.
okay so that means it is more than 12 years
Yes,
and
my
it's a 302 case
Yes, my lord. 302 case, my lord.
what is the prosecution case
My lord, prosecution case is that due regarding a stolen of a dog, the quarrel has been initiated in between the parties. and thereafter they tied the present appellant, present deceased and his brother in a neem tree and caught the hands of both the person. Subsequently, the brother of the deceased has been medically treated and well, and but the person died. Kumar Murmu died.
Hmm.
And so far as the evidence in the trial court concern, my lord, all
No,
the
no.
witness
This IA has been filed for only appellant number 4.
for my lord,
That is Rega Chattar.
Rega Chattar, my lord.
So let us see that evidence of
My lord, only 3 witnesses has been support the case of the prosecution.
who are they?
My lord, PW5, the father of the deceased,
Hmm.
and my lord,
What is the name of the deceased?
my lord Kumar Murmu. PW3, 5.
They are the eyewitnesses to the occurrence.
Yes, my lord.
One is PW3, another is PW5.
My lord, PW5 is the eyewitness to the occurrence. Another is PW7.
Okay. And another?
Another is the injured, my lord.
Who is he?
Injured, my lord.
PW12.
Pidult.
PW12 is the injured. Madam. So let us see that injured statement, what he has stated.
Yes,
Is
my
the
lord.
brother of the deceased?
Yes, my lord. PW. ଆଜ୍ଞା ଅଛି ଅଛି
ପଢନ୍ତୁ deposition copy. ଆପଣ ଦେଇନାହାନ୍ତି? ଆରେ
yes ma'am.
Deposition copy ଦେଇନା?
Give the copies to the state council. How do you provide it so that it can be taken up day after tomorrow? Day after tomorrow. नहीं है क्या? So this will be called on 7th February. Yes. Oh, no.
Day after tomorrow.
Day after list it will be taken up on 7th.
Provide the deposition copies, at least of these 3 witnesses. Okay.
Yes.
Yes.
Item 7.
What is Mr. Mishra? What modification he wants, Mr. Das? Modification of order dated 7/1/20. What is there? So plot number ta 15/1605 जगह रे हबो 51 of 1605 and revenue plot number be corrected as so and so in place of so and so and time limit fixed for so and so we extended. अच्छा पास ओवर करता हूँ कौन से
Item 11.
Item 11, I don't press this matter with that IA matters. That is for implementation order. It might be already
IA number 3199
My lord.
2020. This is an application for implementation of the order dated 24/1/2020.
My lords.
The Learned Council.
It is already complied, I think so. That is not
He
required.
doesn't want to praise his interim application.
Yes, my lord.
So why are you worried? The Learned Council for the petitioner does not want to praise this interim application. Accordingly, IA is disposed of. Yes.
Oblige.
Item 12.
Chairman, I filed IA to change the nomenclature, my lord.
The office has pointed out that the second copy of the brief has not been filed. May kindly be accepted, my lord.
Okay, learned counsel for the petitioner file the second copy of the brief which is accepted. IA number so and so. This is an application for change of nomenclature from WPCRL to CRLMP. The stamp reporter has pointed out that the correct nomenclature is CRLMP. Considering the submission made by the learned counsel for the petitioner, you are for the Union of India and okay, so also hearing. Please give your name for the Union of India. And
Copy maybe, sir. Copy maybe, sir.
give a copy to it.
Copy number 3.
And
Real code.
we are inclined to accept the prayer made in the interim application. Accordingly, the WPCRL be re-registered as CRLMP and be placed before the assigned bench. Yes. Second copy of the IAT.
Item 13.
13 on behalf of Mr. Satyanarayan Mishra, my lord. That the same, the nomenclature is to change, my lord. I is filed for that.
But there are two defects as pointed out.
The defects which they pointed out that the synopsis and the date that has not been filed, that he has compared that the defect is removed, my lord. The instruction what I have received.
Copy note, sir.
My friend is also here.
29 I have.
You are for the?
No, I was on his behalf.
Achha,
My
all right.
friend is here.
So, which copy you want?
That second copy he has not given.
WPCRL copy.
WPCRL copy.
The WPCRL I get again.
A WPCRL is not.
Already.
Provide him a WPCRL copy also. He is not having that.
Yes, my already filed. Already I will supply today.
All right. The learned counsel for the petitioner submits that defect number 6 and 14V as pointed out. Defect number 14 beta to huchi is be registered as CRLMP. All right. Defect number 6 has already been removed. And he has solved the copy. Yes, solved the copy of the WPCRL. So also the interim application on the land and council for the state in court to demo lekhili.
Yes, my already I have.
Oh, the WPCRL ta deina thi na. All right. Then you come to that IA number 2 of 2024. There is an application for change of nomenclature from so on. So usual order for the be placed before the assigned bench. IA disposed of.
Item 14.
My lord, I am on this similar. I may be allowed. My lord, this case, Lordship was pleased to heard this matter. And also on 24th of January 2024, my lord was pleased to pass an order directing the state, London State Council to bring certain resolution of the government service.
Of the Honorable Supreme Court wherein it has been dealt that while determining the entitlement of a convict for premature release, the policy of the state government prevalent on the date of conviction would have to be the determinative factor. However, if the policy which was prevalent on the date of conviction is subsequently liberalized to provide more beneficial terms, those should be borne in mind for premature release of the convict. In the present case, the petitioner was found guilty by the trial court on so and so, it appears from Annexure DY 3. The state government by resolution number so and so have constituted the state sentence review board with a view to review the sentence awarded to a prisoner and for recommending his premature release in appropriate cases. Subsequently, pursuant to the modification of paragraphs 3 and 4 of the guidelines issued by the NHRC in their letter dated so and so, paragraphs 3 and 4 of the government resolutions were modified by resolution number so and so in view of the ratio let down so and so. We feel it appropriate to issue the said resolution number so and so. So also the resolution. The Land Council for the state seeks some time to produce these two resolutions. On the next date, he is also directed to produce the conduct of the petitioner from the Superintendent Circle Jail accordingly put up this matter. Okay. So you have brought it.
No. Conviction in 2004.
Hmm?
Conviction is in
Ah,
2004.
This was pending at that point.
My lord. So 2002 notification was there.
2002 resolution was pending.
2000.
2000. It was amended in that modified in
2022.
2005.
Taper to 10 to 22, then
Right. So
for the 2000 is concerned, my lord, come to page 2.
Page 2.
Para 4, my lord.
Mr. Mishra, have you got a copy of this 2000? Okay.
No, my lord, I have not received it.
He told you he sent someone, no one has come.
Okay, you do one thing, we'll take up this matter tomorrow.
Tomorrow, my lord, I am traveling outside. Not next week, any day. I will examine in the meantime. I'll assist next week.
Para 4. For premature release matter. Eligibility. The following category of convict prisoners undergoing life sentence may not be considered eligible for premature release, namely. Prisoners, first one, prisoner convict of the such rape, dacoity, and terrorist. This is a case of dacoity with public servant, that is 4. Convict who commit under commit murder while involved in smuggling operations of or having committed the murder of public servant. Here a public servant has murder during the dacoity. So at that, nowadays it has been considered that after 25 they can consider.
So that means
There is
this
no
2000 resolution completely
against the petitioner.
Okay.
Prima.
But 2000 latest to 2022 resolution says that it can be only considered after 25 years. Okay. All right, Mr. Mishra, you go through this.
Yes, I will.
You want it to be taken up next week?
Next week, please. That will be.
And what about that other thing? You are also required to.
Other thing, my lord.
Conduct of the
Conduct,
Mr.
And also, my lord, if my lord will consider that
Mr. Das, we have also asked you to produce the conduct of the petitioner from superintendent of the concerned jail. So that you are also.
And which is mandatory follow as per the rule 6. That is missing in the superintendent jails. He has not filed any.
Okay, next week we are taking up by the way next week. So to obtain that, Land Council for the state has produced the resolution dated 26th September 2000 of the Law Department, Government of Odisha, as per the order dated 24/1/2024, which is taken on record. The Land Council for the state submits that in view of clause 4 of the said resolution, the petitioner who is undergoing life sentence is ineligible for the premature release. Let a copy of the resolution be served on the Land Council for the petitioner.
Your lordship may indicate already served. I will collect from Mr. Your lordship may
served on the Land Council for the petitioner. Land Council for the state submits that he may be given some time to obtain instruction regarding the conduct of the petitioner from the superintendent of the concerned jail where the petitioner is lodged. Land counsel for the petitioner also seeks for an adjournment. As prayed for, place this matter, the week commencing from 12th February 2024. Let are taken on record for the
Obliged, my lord.
Mr. Das, that item number 10, which has been filed by Mr. Samir Kumar Mishra regarding the modification of the order, that was filed in 2020. But if we see that order that was passed by this court on 7/1/2020, the operative portion is that we dispose of the writ petition with a direction that in case the petitioner gives an undertaking before the authority that he will hand over the front portion within a period of 15 days, if not already handed over. In such event, the authority shall allot the land to the petitioner on the backside as approved by the government's want so. So, आपरे कौन अपन instruction ले लेनी तारे
Copy
carry
देना
out
sir.
ही यही थी
They are
वो
not solved the copy also.
oh I see.
I'll inform Mr. Mishra, let him know.
Otherwise, we will simply dispose of this
Yeah.
matter. Non-material issue. We are just passing it over. We may take up this matter tomorrow. Just
I'll
intimate.
inform him to confirm.
Item 15.
Your Lordship, I have been appointed as a amicus curiae. If the appellant was convicted under section 302.
Yes, just.
My lord, Superly, item 16, my lord.
15.
Item 16. BL Tripathi and Mr. Gyanarajan, who is now the president, also inform. BL Tripathi is that he is not coming. She is not coming, my lord. So it can be engaged to anyone so that it can be hard.
What about Gyanendra?
That I don't know whether it has been changed or the power has been changed or not. Any other so
ସେ ଜ୍ଞାନେନ୍ଦ୍ର ଚନ୍ଦ୍ର ସ୍ୱାଇଁ କେମିତି ପାୱାର ଫାଇଲ କଲେ ଏଟା ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ମ୍ୟାଟର ତାଙ୍କୁ ଡାଇରେକ୍ଟ ଏନଗେଜ କଲେ କି ନା କଣ ଏଇ ନାମରେ ତ ଓ
तीन चार लेखा ना रोज तो की एक्चुअली रोज जानले
ଏଇଟା ଆଜି ଇଟ୍ appears JCRL ରେ ପାୱାର ଫାଇଲ କରିଦେଇଛନ୍ତି ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ତାଙ୍କର ସବୁ ଆସୋସିଏଟଙ୍କ ସହିତ ଫାଇଟ କରିଥିଲେ
ଆଜ୍ଞା
whether BL Tripathi was engaged as by this court or by the legal aid or also filed vinama for the appearance without taking consent of the advocate. Acha. Non appears ଚାଲିଛି
ଆଜ୍ଞା ସିଏ ଆସୁନାହାନ୍ତି କେବେ ଲାଷ୍ଟ ୱିକରେ ଥିଲା ଗୋଟେ ଆଉ ଜଣ अलग करछे
ନାଇଁ ଠିକ ଅଛି ମୁଁ କହିଲି ଏଇ ଯୋଉ ସିଏ ଯୋଉ वी ନାମାଟା ଫାଇଲ କରିଥିଲେ
ଆଜ୍ଞା
ତା ଦେହରେ ଜ୍ଞାନେନ୍ଦ୍ର ଚନ୍ଦ୍ର ସ୍ୱାଇଁଙ୍କ ନାଁ ନଥିଲା
ଆଜ୍ଞା
ତ ତାଙ୍କ ନାଁ କେମିତି ଆସିଲା ଜ୍ଞାନେନ୍ଦ୍ର ଚନ୍ଦ୍ର ସ୍ୱାଇଁଙ୍କୁ କିଏ ଏନଗେଜ କଲା ହଁ ନା ସିଏ ତାଙ୍କୁ ଆମାଇକସ୍ କ୍ୟୁରି ନା କଣ କେମିତି ଅଛି ଆଉ ତାଙ୍କ ନାଁଟା କେମିତି ଆସିଲା ନା ନାହିଁ ଓକାଲତନାମାରେ ତାଙ୍କ ନାଁ ନାହିଁ ତାଙ୍କ ନାଁଟା ବର୍ତ୍ତମାନ ଯୋଉ ଲିଷ୍ଟରେ ଆସିଛି କେମିତି ଆସିଛି ପଚାରୁଛି ପୁରା ଜ୍ଞାନେନ୍ଦ୍ର ଚନ୍ଦ୍ର ସ୍ୱାଇଁ ବୋଧେ ପ୍ରଥମରୁ ଏନଗେଜ ହେଇଥିଲେ ଓ ଆଇ ସି ଜ୍ଞାନେନ୍ଦ୍ର ଚନ୍ଦ୍ର ସ୍ୱାଇଁ ପ୍ରଥମରେ ଲିଗାଲ ଏଡ୍ ଏନଗେଜ କରିଥିଲେ
ଆଜ୍ଞା
ତାପରେ ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ତାଙ୍କର ଫାଇଲ କଲେ ପାୱାର so now both are not appearing କିଏ ହଁ ଗୋଟେ ପ୍ରିଜନର୍ସ ପିଟିସନ ଆସିଥିଲା ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ସେ ତ appear କରୁନାହାନ୍ତି ତେଣୁ ବର୍ତ୍ତମାନ ଆଉ ଜଣ
ସୁଶାନ୍ତ କୁମାର ତ୍ରିପାଠୀ
ଏଟା ଦେଇଦିଅ ସୁଶାନ୍ତ କୁମାର ତ୍ରିପାଠୀଙ୍କୁ କରିଛି ହେଲେ paper book is to be hand over
ହଁ
to
ସେ ଯାଇ ଆସିବେ
ହଁ
ଥିଲେ
so ତାଙ୍କୁ engage କରିଦିଅ
sole appellant before your lordship, my lord. He has been convicted under section 302, read 201, my lord. Under 302, my lord, arrive for life, and under 201, my lord, 3 years, my lord. The sentence are on concurrently, my lord, as per direction of the learned trial court, my lord. Here, my lord, during trial, my lord, 12 prosecution witnesses are examined, my lord. And the conviction based on only, my lord, the child witness, PW 2, and the
FIR,
my lord,
41.
my lord. PW 3 is the informant, my lord, lodged affair, my lord. Page 41, my lord. ଦରଖାସ୍ତକାରୀ ମୁଁ शेख ଆସିମୁଦ୍ଦିନ, ବୟସ 68 ବର୍ଷ, PW 3, my lord. ମୁଁ शेख ଆସିମୁଦ୍ଦିନ, ବୟସ 48 ବର୍ଷ, ପିତା शेख ମହମ୍ମଦ, ଚଅଟା ଧର୍ମଶାଳା, ଜିଲ୍ଲା ଯାଜପୁର। ଘଟଣା ଏଇକି ଯେ ଆଜକୁ 12 ବର୍ଷ ପୂର୍ବେ ମୋର ଝିଆରୀ ଚାନ୍ଦ ବିବି, ବର୍ଷ 35 ବର୍ଷ, ସ୍ୱାମୀ ଗିରି ମଣ୍ଡଳ, ପିତା ମାୟାଧର ମଣ୍ଡଳ, ସା ଚଅଟା ଥାନା ଧର୍ମଶାଳା, ଜିଲ୍ଲା ଯାଜପୁରକୁ ଭଲ ପାଇ ବିବାହ କରି ଜାରକାଠାରେ କୁକୁଡ଼ା ବଲର ଦୋକାନ କରି ଭଲରେ ଚଳୁଥିଲେ। ମଝିରେ ମଝିରେ
Mandal is the appellant in this case, right?
my lord.
Yes.
ମଝିରେ ମଝିରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଦୁଇ ଜଣଙ୍କ ମଧ୍ୟରେ କୌଣସି କାରଣକୁ ନେଇ ଝଗଡ଼ା ମାରପିଟ ହୁଅନ୍ତି, ଯାହାକୁ ଆମ୍ଭେ ଦୁହିଁଙ୍କୁ ବୁଝାସୁଝା କରି ଦେଉ। ଚାନ୍ଦି ମଧ୍ୟ ମଝିରେ ମଝିରେ ଆସି ଆମ ଘରେ ବୁଲିଯାଏ ଓ ମୋର ଖାଇବା ସୁବିଧା ଅସୁବିଧା ବୁଝିଯାଏ। ଆଜକୁ 10 ଦିନ ହେବ ଚାନ୍ଦି ଆମ ଘରକୁ ନ ଆସିବାରୁ ମୁଁ ଜାରକା ଯାଇ ତାକୁ ଦେଖା କରିବାକୁ ଚାହିଁବାରୁ ଯେତେ ଡାକିଲି,
Chandi Bibi is the deceased.
wife of the appellant.
Okay.
ଚାହିଁବାରୁ ଯେତେ ଡାକିଲି ଗିରିମଣ୍ଡଳ ଓ ତାର ସାନ ଭାଇ ଚୁଟୁକୁନୁ ମଣ୍ଡଳ କହିଲେ ସେ ଶୋଇଛନ୍ତି, ତୁ ଯା ପରେ ଦେଖା କରିବ। ମୁଁ ମୋର ନାତୁଣୀକୁ ପଚାରିବାରୁ ସେ କହିଲା, ମା ନାକରୁ ରକ୍ତ ଗଡୁଛି, ସେ ଶୋଇଛି। ଗିରି କଥାରୁ ମୁଁ ଭାବିଲି ଗରମ ହେତୁ ରକ୍ତ ବାହାରୁଥିବ, ତେଣୁ ପଳେଇ ଆସିଲି। ଆଜି ଯାଏଁ ଚାନ୍ଦି ନ ଆସିବାରୁ ମୋ ମନରେ ସନ୍ଦେହ ହେଉଛି ଗିରି ତାକୁ ଜୀବନରୁ ମାରି କେଉଁଠି ପୋତି ଦେଇଛି, ଯାହାଫଳରେ ମୋ ଝିଆରୀର ପତ୍ତା ମିଳୁନାହିଁ। ଏଣୁ ଆପଣଙ୍କୁ ବିନୀତ ଅନୁରୋଧ କଲି, ଆପଣ ଦୟାପୂର୍ବକ ତଦନ୍ତର ମତେ ନ୍ୟାୟ ଦେଲେ ଦୋଷୀକୁ ଦଣ୍ଡ ବିଧାନ କରାଇଲେ ମୁଁ ବିଶେଷ ଉପକୃତ ହେବି। This is the FIR mallet against 2 persons.
ଯୋଉ ଲେଖିଲା ଯେ ମୁଁ ମୋର ନାତୁଣୀକୁ ପଚାରିବାରୁ ସେ କହିଲା, ସେ ନାତୁଣୀ PW କେତେ?
2, my lord.
So what are the materials available against the appellant as per the prosecution case?
My lord, 3, the one is child witness.
He is eyewitness to the occurrence?
Yes, my lord.
Okay, PW2, that PW2 is the
Asa Mandal is the daughter of the
appellant and the deceased. All right. Daughter of appellant and deceased. She is the eyewitness. What is her age, by the way?
10, my lord. 10 years, my lord.
Okay, this one is that eyewitness. What else is there?
Other, my lord, the extrajudicial confession before, my lord, 10 and 11.
4 and 5.
No, seta extrajudicial confession. No, 4 and 5, my lord.
PW4 and PW5 are 2 witnesses to
the extrajudicial
confession.
My lord.
Just a minute. Yes.
Another, my lord, 10 and 11 leading to discovery of the dead body.
PW10 and PW11 witnesses to leading to discovery. Okay. What was recovered at the instance?
Dead body was recovered.
Dead body
was recovered.
Where was the dead body?
Dead body was the appellant was dig the dead body near a pond.
Is it dead body was buried in the
pond, near the pond re pokhore poti deythile.
Buried near the pond. There was water in the pond. Okay. Near that it was buried. All right. And This is one thing. And what is the cause of death as per the doctor?
Cause of death, my lord, as per the PM report,
Who is the doctor?
PW1 is the doctor, my lord.
Due to shock caused by extensive chest injury,
Chest injury.
which were antemortem in nature.
And time gap between the PM and the death?
7 to 10 days.
7 to 10 days.
That is the body has been recovered after a lapse of 10 days.
10 days. It was what, in what position it was there?
It was the position of decomposition. You know.
Decomposition.
It was decomposed.
So these are all the evidence.
Evidence.
So let us come to that child's evidence, what he has stated.
Yes, my lord.
PW2.
2, my lord. Page 52 of the paper book.
Yes.
My lord, tested the veracity of the witness by putting some intelligent questions to her, to which she gave rational answers. My lord, the informant is my grandfather. The accused is my father. My mother, Chandi Bibi, expired about 1 year, 1 month back. After taking my meal, I was sleeping inside my house. After hearing cry of my mother, I woke up and saw my father was assaulting my mother by means of a thenga on her chest. I cried. My mother asked me to give water, but my father denied to give water to her. Thereafter, my mother was repeatedly asking for water and ultimately she died. The dead body of my mother was lying inside the shed room for 2 days. My father told sleeping injection was applied to her, so she was sleeping. 2 days after my father cried, 2 days after my father carried the dead body of my mother to the backside of our house and buried under it. At that time, we were residing at Jarka Market. Police came for investigation. I was examined by the police. Then, my lord, cross-examination part, my lord. 8 to 10 days after the occurrence, I was examined by the police. I was at Chahata in the house of my grandfather Oja while I was examined by the police. I went to the house of my grandfather Oja 3 to 4 days before my examination by the police. My grandfather and grandmother had never tutored me to speak about the gondogolo between my father and mother. I have also not told about the gondogolo between my father and mother to my grandfather and grandmother. My grandfather and grandmother asked me about the occurrence, but I did not tell them anything. When I was examined by police, my grandfather and grandmother were present near me. My grandfather and grandmother took me before the police. I was examined by police at the police station. The house where my father, mother, and myself were residing at Jarka Market consists of 2 rooms. I was sleeping in the same room where my mother was sleeping. The occurrence took place inside the same room. I was liked by father and mother both. My father was assaulting me. Sometimes my mother went to her father's house after Gondogolo with my father. During the period, my mother stayed at her father's house sometimes. I resided with my father and at times I was going to my grandfather's house. Prior to this incident, there was a Gondogolo between my father and my mother was going to her father's house at that time, and at that time I was staying with my father. It is a fact that I have stated before the police many days before the occurrence. My mother, Chand Bibi, was staying in my grandfather's house after quarreling with my father and at village Chahata, and at that time I was also staying with my mother. It is not a fact that I have not stated before the police that my mother expired. It is not a fact that I have not stated before police that hearing cry of my mother, I woke up during night. It is not a fact that I have not stated before the police that my mother expired after repeatedly asking for water. It is not a fact that I have not stated before police that the dead body of my mother was inside the room for 2 days. It is not a fact that I have not stated before the police that my father told sleeping injection applied to her so she was sleeping. It is not a fact that I have not stated before police that 2 days after my father carried the dead body of my mother to the backside of our house and buried under earth. It is not a fact that myself and my mother were residing at my grandfather's house at Chohota during the relevant time. It is not a fact that I am deposing falsehood at the instance of my grandfather and grandmother.
These contradictions which have been put
My lord.
previous statement, whether it has been proved through the investigating officer.
Yes, my lord.
Who is that IO?
IO, my lord, PW12.
Which is that page?
The PW12, my lord.
A contradictions code PW12 bro. Who page re?
Yes, my lord. Cross-examined by defense paragraph page 81, paragraph 5.
Let us see that.
Paragraph 5, my lord.
Hmm.
I had examined the neighbors of the accused. I had not made any requisition for grouping of blood of the accused. I had examined Asa Mandal. She had not stated before
Asa Mandal means this
this child witness, my lord. The
PW,
my lord.
PW2.
My lord.
Okay. She had not stated
Before me that she got up hearing the row of her mother. She had also not stated before me that the dead body of her mother was for 2 days inside the house, and her father told her that sleeping injection was given to her mother, and so she was sleeping. She had also not stated before me that the dead body of her mother was inside the house for 2 days, and 2 days after her father carried the dead body of her mother to the backside of their house and buried it under earth. It is not a fact that my investigation is.
But so far as that assault part is concerned,
My lord.
There is no such contradiction because what she has stated that when she heard cry of her mother,
My lord.
she woke up and saw the father was assaulting her mother by means of a thenga on her chest.
My lord.
This part there is no contradiction,
No
right?
contradiction.
And
the weapon also that was not recovered. The thenga was not recovered.
What is the cause of death as per the
Cause of death, my lord, PW1, the postmortem doctor, my lord.
Paragraph 3 of the postmortem.
Postmortem, internal injury, my lord.
Koda kaile?
Page 49, internal injury, page 49, paragraph 3. Right lung soft collapse reduced to a small black mark. No injury detected on the left side of thorax. Heart chambers are collapsed without any blood. Abdomen soft wall rusting out in the middle, 6-inch length into 2-inch breadth, through which small intestine came out. Stomach collapsed, soft and dark brown, and changed into a pulataceous mass. Intestine were distended, liver decomposed, and coal black color. Spleen soft, pulpy, and contracted into a black mass. Kidney brown in color. Uterus known pregnancy stage. The mode of death was due to shock caused by extensive chest injury, which are antemortem in nature. Time since death, 7 to 10 days from the time of postmortem examination.
So how do you get over this particular line? This statement of the child that she saw her mother was assaulted by means of a thenga on her chest, and the doctor's evidence that the mode of death was due to shock caused by extensive chest injury which were antemortem in nature, and that was 7 to 10 days prior. So if these two things are taken into account, then It appears that the ocular evidence corroborates the version of this other. There are contradictions so far as how many days the dead body was kept in the house,
My lord.
and about the statement made by the appellant that injection was administered. Those are there, but we are concerned with the assault part.
My lord, my humble submission with lordship. My lord, PW3 is the informant who went to the house of the appellant, where he asked the query into the PW2, my lord, child witness. He never disclosed, my lord.
No.
He never disclosed that
After-
my father was assaulted by means of a thenga.
What the child stated before the PW3, that cannot be a ground to disbelieve that because we have to see when the child witness.
Well, my lord, the child witness was in the custody of the informant and his grandfather and mother, my lord.
In whose custody?
After the
whose custody she will be there after
my lord, since
the
8
mother
and 10
died.
days, my lord, she may be tutored, my lord, by the parents.
That you presume that she
Yes.
might have been tutored. She might be telling also truth. There is chance that when a child witness is examined, the court is to be more careful.
Yes.
Because there is possibility of tutoring.
Yes.
And but here you have put a very direct question that to ବୁଢାବାପା ବୁଢୀମା ବା ଅଜୟ ତତେ ଏଗୁଡାକ ସବୁ ଶିଖେଇକିନି କୁହାଉଛନ୍ତି, ସେ ମନା କରୁଛି ଯେ
ସେଟା ସେ ଗଣ୍ଡଗୋଳ କଥା କହୁଛି, ଗଣ୍ଡଗୋଳ କଥା।
Tutoring also yes stated.
My grandfather and my grandmother have never tutored me to speak about the Gondogol before
Yes.
to answer.
Yes, man. This is the
I've also
gondogol in
not
between
tutored.
the parents, my lord, during their lifetime.
No, anything you have brought out in the cross-examination to say
My
that
humble
she has
submission, my
been
lord, since
tutored.
he is in custody of the parents,
Maybe
since 8 to 10 days, my lord, there is every possibility of tutoring, my lord.
ଜଣେ ସିଏ ଆଉ କାହା
And the
କଷ୍ଟଡିରେ ରହିଥାନ୍ତା? We are asking
custody
that
of the my lord, I am saying so. What prevented the IO to examine from the first instance, my lord? There are two daughters, my lord. They are staying with the parents, my lord. The one was choose to examine 8 years and 10 years daughters, my lord. One was took the PW2, my lord. Why not the other daughter, my lord, Usha Mandal, my lord?
how do you get over this witness?
My humble son, he has been tutored by the parents, my lord. Since he has been examined after 8 to 10 days after the incident by the IO.
Because it was detected, that body was detected after
8 to 10 days.
8 to 10 days.
My lord.
And then this, when the FIR was lost,
and on 5/6, my lord.
then when the dead body was recovered?
On 6/6, on 5/6, my lord, on the date of FIR, there was a missing report. Then, my lord, the FIR was registered. On the same day, the dead body was recovered and the appellant was arrested on 6/6, my lord. On the next day, appellant was arrested, then the dead body was recovered.
Yes. And the dead body was recovered from a place which was within your exclusive knowledge, because nobody could be aware that there the dead body has been exhumed. It was exhumed from that portion or that part of that pond. So it was within your special knowledge. If it was not lying in openly so that everybody can see it, so that, but when you are
sketch map of the paper book. Sketch map of the paper book.
Yes.
Your lordship, see, A is the kitchen, my lord. B is the roof of the accused. C is the boiler farm. And D is the open place. Then, man, E is the place, my lord, where, my lord, your lordship, see the distance. Where the dead body was recovered. That was, my lord, outside the house, my lord.
ଆରେ outside the house ଏଟା ପୋତା ହେଇକିନି ଥିଲା ପରା।
ଆଜ୍ଞା।
ତାକୁ ଆପଣଙ୍କର ନେଇକି ଗଲେ ସେଠୁ ପୋତା ହେଇକିନି ବାହାରିଲା। ଆଉ outside the house ହେଇନଥାନ୍ତା କଣ ଘର ଭିତରେ ପୋତିଥାନ୍ତା?
My lord, my in 313 examination, I stated before the police, my lord, there is a 498 case. I have been convicted. After that, my lord, the deceased was staying with the parents, my lord.
This is staying with the parents that cannot be believed because of the child's version. Once the child version is accepted and it is accepted that at your many days before the occurrence, my mother also was staying in my grandfather's house after quarreling with my father and the answer at the time I was also staying with my mother. Cross exam center question. Page 56. ଏ ଛୁଆଟାର ବାହାର କଲ 161 ଆଶା ମଣ୍ଡଳ ଏଇଟା ଆଶା ମଣ୍ଡଳ ବୟସ 16 ମୋତେ ଅଜା ଘର ଆଶା ବିବି ବୋଲି ଡାକନ୍ତି। ମୁଁ ମୋର ଛୋଟ ସାନ ଭଉଣୀ ଜାରକା ବଜାରରେ ବାପା ଓ ବୋଉ ଚାନ୍ଦ ବିବିଙ୍କ ସାଙ୍ଗରେ ରହୁଅଛି। ମୋର ବାପା ମା ଜାରକା ବଜାରରେ କୁକୁଡ଼ା ପାଳି ଆମକୁ ଚଳାନ୍ତି। ମୋର ସାନ ଭଉଣୀ ଉଷା ମଣ୍ଡଳର ବୟସ 6 ବର୍ଷ ଅଟେ। ବହୁତ ଦିନ ତଳେ ମୋର ମା ଚାନ୍ଦ ବିବି ବାପାଙ୍କ ସାଙ୍ଗରେ ଝଗଡ଼ା କରି ଚହଟା ଅଜା ଘରେ ରହୁଥିଲା। ଆମେ ମଧ୍ୟ ମାଙ୍କ ସାଙ୍ଗରେ ରହୁଥିଲୁ। ଏବେ କିଛି ଦିନ ହେଲା ଆମେ ମା ସହିତ ବାପାଙ୍କ ପାଖରେ ଜାରକା ବଜାରରେ ରହୁଥିଲୁ। ଗଲା 8 ଦିନ ତଳେ ଦିନେ ରାତିରେ ମୁଁ ମୋର ସାନ ଭଉଣୀ ଡ୍ରାମା ଦେଖିବାକୁ ବାପାଙ୍କ ସାଙ୍ଗରେ ଆସିଥିଲୁ। ଡ୍ରାମା ଦେଖିସାରି ରାତିରେ ବାପାଙ୍କ ସାଙ୍ଗରେ ଘରକୁ ଫେରିଲୁ। ଘରେ ପହଞ୍ଚି ବାପା ବୋଉ ସାଙ୍ଗରେ କଳି କଲେ। ଆମ ଦୁଇ ଭଉଣୀକୁ ବାଡ଼େଇଲେ। ଆମେ ଦୁଇ ଭଉଣୀ ଶୋଇଲୁ। ମୋତେ ନିଦ ଲାଗୁନଥାଏ। ବାପା ଗୋଟିଏ ମୋଟା ବାଡ଼ିରେ ଓ ହାତରେ ବୋଉକୁ ଖୁବ୍ ଜୋରରେ ବାଡ଼େଇଲେ। ମା ମାଡ଼ ଖାଇ ତଳେ ପଡ଼ିଗଲା। ପାଣି ମାଗିଲା। ବାପା କହିଲେ କେହି ପାଣି ଦେବେ ନାହିଁ। ତାପରେ ପୁଣି ମାକୁ ମାରିଲେ। ମାର ଚେତା ବୁଡ଼ିଗଲା ଆଉ ପାଟି ନକରି ଶୋଇ ପଡ଼ିଲା। ସେଇ ଘରେ ମାକୁ ଘୋଡ଼ାଇ ରଖିଲେ। ସକାଳୁ ଉଠିବାରୁ ଆମେ ବାପା ସେ ଘରକୁ ଛାଡ଼ିଲେ ନାହିଁ। ବାପା କହିଲେ ତୋ ବୋଉ ବ୍ରହ୍ମବରଦା ଓ ଯାଜପୁର ଯାଇଛି। ତାପରେ ଆମେ ସେ ଘରକୁ ଦେଖିଲୁ ବୋଉ ନାହିଁ। ବୋଉ ଆଜି ପର୍ଯ୍ୟନ୍ତ କୁଆଡ଼େ ଗଲା ଫେରି ନାହିଁ। ସୋ ଏଇ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟଟା ତାକୁ ପଚାରିଲେ, it is a fact that I have stated before police that many days before the occurrence, my mother Chedabai was staying in my so-and-so house after quarreling. And at that time, I was also staying with my mother. That is a correct statement. But again, she has stated that we returned back few days prior to the occurrence. Hala? So, in the backyard of your house, there was a pond, and near that pond, the dead body was buried, and it is you within whose special knowledge it was, and you led to the recovery of that dead body that has been deposed to by, as you said, PW 10 and PW
11, my lord.
11.
They have hostile, my lord. They have turned hostile, my lord.
No. Let us see that, because IO must have stated like that.
Yes, IO is stated, Your Lordship. Second paragraph, it's page 79.
So 10 and 11.
My lord. Page 74.
Okay, both of them have not supported this.
My lord.
Now, what the IO has stated about this recovery of the dead body at the instance of the appellant?
Lordship, paragraph 2, page 79, my lords.
EW 12 IO. ପଢନ୍ତୁ।
My lord, on 6/6/2003, acting upon a reliable information, I proceeded to Jarka Bazar and had apprehended the accused there. I arrested the accused on the same day at 2 p.m. The accused, while in police custody, had stated that he had kept the dead body of his wife concealed under the earth at the backside of his house at Jarka Bazar and led me and other witness to that place, pointed to the place where the dead body was concealed. I recorded his statement in presence of witnesses. Exhibit 7/2 is the statement of the accused, which I have recorded. Exhibit 7/3 is my signature. I sent requisition for the executive magistrate and the medical officer. On arrival of the executive magistrate and the medical officer, the place.
Executive magistrate examine each of the.
Na. Hey, nothing.
Okay. Yes, medical officer.
And the place which was pointed by the accused was dug by the help of informant and others. The dead body of the wife of the accused was recovered from inside the dug place. The dead body was identified by the informant and others as the wife of the accused. I conducted inquest of the dead body of the deceased and had prepared inquest report. Exhibit 3. Exhibit 3/5 is my signature.
So after the dead body was recovered from that place where it was buried, the inquest was conducted, right? So let us see that inquest report. Jarka Bazar Sthito, place 3 number, place where the dead body was found. ଜାରକା ବଜାର ସ୍ଥିତ ରାସ୍ତାର ପୂର୍ବ ପଟେ ସରକାରୀ ଅନାବାଦୀ ଜାଗା ଉପରେ ଶ୍ରୀ ଗିରିଧାରୀ ମଣ୍ଡଳ ପିତା ସୁଆଂଶୁ ରହିବା ସ୍ଥାନରେ ଗିରିଧାରୀ ମଣ୍ଡଳ ଇଜ ଦି ଆପାଲାଣ୍ଟ ବାସଗୃହର ପୂର୍ବ ପଟ ଦଖଲରେ ଥିବା ଅଗଣାରେ ଥିବା ଗୋଟିଏ ବଡ଼ ଖାଲରେ ପୋତା ହୋଇଥିବାର ତଳ ଉପରକୁ ଉକ୍ତ ସୁଆଂଶୁ ଖାଲରୁ ମାଟି ଖୋଳାଯାଇ ଅଣାଯାଇ ପଚିଯାଇ ଫୁଲି ଯାଇଥିବା ଅବସ୍ଥାରେ ଖାଲରୁ ଉପରକୁ ଅଣାଗଲା। ମୁତଫି ମୁଣ୍ଡ ଉପରକୁ ଥାଇ ଗୋଡ଼ ଦୁଇଟି ଦକ୍ଷିଣକୁ ଥାଇ ଦୁଇ ହାତ ଶରୀରର ସୁଆଂଶାଇ ଦୁଇ ଗୋଡ଼ ଦକ୍ଷିଣକୁ ଥାଇ ନିର୍ଦ୍ଦେଶ କରୁଥାଇ ଚିତ୍ ହୋଇ ପଡ଼ିଥିବା ଅବସ୍ଥାରେ ପାଇଗଲା। ମୁତାଫିକୁ ଓଲଟ ପାଲଟ କରି ସାକ୍ଷୀ ଓ ମାଜିଷ୍ଟ୍ରେଟଙ୍କର ଉପସ୍ଥିତିରେ ଦେଖିବାରେ ମୁତଫିର ଶରୀର ସମ୍ପୂର୍ଣ୍ଣ ରୂପେ ପଚି ସଢ଼ି ଚମଡ଼ା ଛାଡ଼ି ଯାଇଥିଲା, ମୁଣ୍ଡର ବାଳ ସମ୍ପୂର୍ଣ୍ଣ ଉପୁଡ଼ି ଯାଇଥିଲା, ପେଟରୁ ଅନ୍ତବିଜୁଳା ବାହାରି ଯାଇଥିଲା। ତାପରେ ମୁତଫିର ଶରୀର ଅତ୍ୟନ୍ତ ପଚି ଯାଇଥିବାରୁ ଆଘାତ ବିଷୟରେ ଜଣା ପଡୁନଥିଲା। ମୃତକୁ ମାରି ଦେଇଥିବା ସନ୍ଦେହ କରାଯାଏ। ମୁତଫିର ଅଣ୍ଟାର ଚତୁଃପାର୍ଶ୍ୱରେ ଗୋଟେ କଳା ରଙ୍ଗରେ ଚିରି ଯାଇଥିବା ସାର୍ଟରେ କିଛି ଅଂଶ ବନ୍ଧା ହୋଇଥିଲା। ମୁତଫିର ଡାହାଣ ହାତରେ ପିତ୍ତଳର ବଳା ଥିଲା। ମୋର ଝିଆରୀ ଚାନ୍ଦ ବିବିକୁ ଗିରିମଣ୍ଡଳ ମାରି ଖାଲରେ ପୋତି ଦେଇଛି। That was the signature. Inquest was in death of the deceased so and so. Additional Tahsildar, Executive Magistrate has also signed, but he could not be examined during trial. Other witnesses, these independent witnesses, they have not supported, though their signatures are appearing. But SI, he has proved his signature, and Sheikh कौन था ना असीम मलिक ସିଏ ତାର ଗୋଟେ noting ଅଛି okay but Mr. Mishra,
Lordship,
in this inquest report,
my lords.
there is nothing that the dead body was recovered at the instance of the. There is nothing, not a single line at the instance of the appellant. Rather, as it appears that ଖୋଳା ହେଇକିନି ବାହାରିଲା ଲେଖା ହେଇଛି ପଚି ସଢି ଯାଇଥିବା ଅବସ୍ଥାରେ କିନ୍ତୁ appellant ସେତେବେଳେ ଉପସ୍ଥିତ ଥିଲା ବା ତାର ଇନଷ୍ଟାନ୍ସରେ ଖୋଳା ହେଇଛି ଏ ବିଷୟରେ ଆଦେହରେ ଉଲ୍ଲେଖ କିଛି ନାହିଁ.
That PW12 and PW3 have stated, Your Lordship. PW3 is the informant. He has also stated that he had accompanied them while the accused indicated the spot.
No, he said that 10 and 11 are the witnesses to the
Lordship.
leading to discovery.
My lords.
So apart from that, PW3 is also.
Yes, PW3 has also
He has
stated.
not stated that.
He is the informant.
No, PW10, you said that PW10 and 11 did not support that,
Minor.
right?
Minor.
But PW3 has also stated about leading to discovery.
Lordship.
He is the informant in
He brought out the dead body from the.
Let us see that.
He is the informant. Page 55, Lords. 50 of the paper book.
Sheikh Asimuddin.
My lord, he is the informant.
PW3.
May I read, my lord?
Informant. Okay. Please, please.
My lord, I am the informant of this case. I know the accused standing in the dock, who is the husband of Chand Bibi, my niece. The marriage between the accused Chand Bibi took place at 13 years back. They got married by registration in the court. 1 year, 1 month back, the accused killed his wife Chand Bibi and buried the dead body under earth. At the relevant time, the accused and his wife Chand Bibi were residing at Jarka market and opened a boiler farm there. Chand Bibi used to come to my house to look after my well-being. During the relevant period, she did not come to house continuously for 8 to 10 days. I came to Jarka and asked the accused about Chand Bibi. The accused threatened me to assault, saying, "Tu kiye khabara bujila wala." Out of suspicion, I came to Dharmasala PS and lodged written affair. This is the written affair lodged by me at the police station marked at Exhibit 2, and Exhibit 2/1 is my signature. Police investigated into the case and interrogated the accused, and the accused confessed his belief that he had killed Chand Bibi and buried the same under the earth. He gave statement before police that he had buried the dead body in the backside of the house under a godia, and so saying, he led the police and witness to the place of concealment and shown the place whereafter the dead body was recovered from that place, and I identified the dead body to be the dead body of Chand Bibi, and police held inquest over the dead body of the deceased in my presence. I gave my signature in the inquest report. Exhibit 3 is the said inquest report, and Exhibit 3 is my signature. Then cross-examination part, my lord. There are 2 shops near the place of recovery of the dead body. Those 2 shops belong to Sonia Manti and Raja. And after the shop of Sonia Manti, there is no other shop. I have not seen the court marriage between the accused and Chand Bibi. I do not know if Chand had filed a case against accused on the allegation that the accused drove her out from his house. I am not a witness in any such case. I lodged affair on 5/6/2003, but I cannot say the name of month. On the very day I was searching for Chand Bibi at the house of accused, I lodged affair in that night. I was examined by the police on the same day. On the same night, police brought the accused to the police station. During that night, the accused remained in the PS. On the next day morning, when the police asked, he gave his statement. Police called me to PS. On the next day morning at 5 to 6 a.m., after the accused gave statement at 6 a.m., I returned back to my house. PW2 Asa is my granddaughter. It is a fact that I have mentioned in my affair that on my query, my granddaughter Asa told me that her mother is sleeping as blood coming out from her nose. The dead body which was recovered was not decomposed, but the skin was normal. The dead body was recovered at 4:30 to 5 p.m. I myself dig earth, brought out the dead body. Besides independent witness, police staff, doctor, Tahsildar were present at the time of recovery of dead body. The police staff, Tahsildar, left the place at 5:30 p.m. to 6 p.m. I was examined by the police on the next day morning after the accused confessed before them. It is not a fact that I have not stated before the police that accused gave statement that he has killed her wife and buried her dead body under the earth. It is not a fact that I have not stated before the police and not mentioned in my affair that 1 year, 1 month back, accused killed her wife Chand Bibi and buried her dead body. It is not a fact that I have not mentioned in my affair nor stated before police that I inquired about Chand from accused who threatened me to assault saying to kiye khabaro bujila wala. When I gave my signature in the inquest report, it was mentioned therein that the dead body was decomposed, so the place of injuries could not be marked. It is not a fact that accused did not give any statement before the police. It is not a fact that there was no recovery of dead body from the place of concealment being shown by the accused. It is not a fact that the dead body of Chand Bibi was not recovered. The dead body was recovered after we dug earth up to 3 to 4 feet, half trip of crusher, dust cover at that place. It is not a fact that I am deposing falsehood.
So this version, and you can see the IO's version. Well, IO has in paragraph number 2, which you just placed. So the place from where the dead body was recovered, it was buried, and the statement of the child witness PW2, then extrajudicial confession evidence kon aschi?
PW 4 and 5,
Five,
my lord.
well.
They have supported or hostile?
Supported, yes, sir.
No, the PW4, my lord, the PW4.
Come to PW4.
My lord. I am reading, my lord, page 59, paper, my lord. No. I know the informant, my lord, and the accused standing in the door. I also know the deceased Chand Bibi. The deceased Chand Bibi is the wife of the accused. Chand Bibi expired 12 to 13 months back. One day, the accused came to tea stall situated near my betel shop in the morning at 7:30 to 8 a.m. He himself disclosed before us that he has killed his wife, Chand Bibi, and told he is going to surrender before the police. Then cross-examination on behalf of the accused, my lord. I have seen police came to Jarka to the house of the accused along with him. It was about 9:30 a.m. when police and accused went towards his house. The tea stall where the accused narrated the incident is adjacent to my betel shop. 10 to 12 persons present when the accused told about the incident before us. The accused was talking like a madman at that time. None of the people present there detained him for going to the PS. The PS is at a distance of half kilometers from my betel shop. I was not examined by the police. It is not a fact that accused did not confess before us.
Yes, next witness, PW5.
My lord. Page 61, my lord. I may be reading one.
Yes.
I know the informant and the accused standing in the dock. I also know the deceased Chand Bibi since died since more than 1 year. Accused is a husband of the Chand Bibi. One day at 7 a.m. in the morning, I was taking tea in a tea stall at Dharmasala market. The accused came there. I asked him where he had come so early in the morning. The accused replied that he has killed his wife, Chand Bibi. The accused also took tea in the said tea stall. At that time, accused was residing at Jarka market, opening a broiler farm along with his wife, Chand Bibi, and children. I have stated these facts before police. My lord, on cross-examination, accused came to the tea stall in between 7 to 7:30 a.m., left the tea stall at about 8 a.m. he went to PS. I cannot say if he had returned along with the police. The said tea stall belonged to Sachikanta Mahanti. The beetle shop of Pidol 4 is in front of the tea stall, intervened by the road. 4 to 5 persons were present.
means PW4.
My lord. In front of the tea stall, intervened by the road. 4 to 5 persons were present when the accused disclosed that he had killed his wife. The accused disclosed just in front of the tea stall where we were sitting on a bench. Myself and Pidol 4 were present, but I cannot say the names of other present as there I did not know them. The Dharmasala PS is at a distance of 5 kilometers from my house. The tea stall where we are sitting is also at a distance of 5 kilometers from PS. Prior to the date, I have not heard about missing of Chand Bibi. The house of Pidol 3, Sheikh Asamuddin, is at a distance of 300 feet interval by house from my house. I was examined by police 5 to 6 days after the accused disclosed this fact before us. It is not a fact that I have not stated before the police that I was taking tea at a tea stall at Dharmasala market where the accused came and disclosed that he had killed his wife, and I asked him why he came so early in the morning. It is not a fact that I have not stated before the police that the accused also took tea and that accused was staying at Jarka market along with his wife and children. It is not a fact that the accused did not confess before us. It is not a fact that I am deposing falsehood at the instance of Pidol 3 Asimuddin as he is my neighbor. Co-villager.
No, this paragraph 3 रो जो contradiction प्रमाण है कि नहीं जो it is not a fact that I have not stated before the police that the accused came and disclosed that he had killed his wife when I asked why he was come to so early. Who is that investigating officer?
Pidol 12 madam.
Pidol 12 तो किसी प्रमाण करेनी
No,
तमन
that not been asked.
So if you just put the question to the witness, confront it but not proved through the IO, then that is not proved, so that cannot be taken into account. So not only you are to draw the attention of that witness to the previous statement, but that is also to be proved through the IO. এবং ବୋଧେ ତାମାନେ ଏଇ ବୋଧେ କହିଥିଲା 161 ଆକୁଳି ସ୍ୱାଇଁର ଷ୍ଟେଟମେଣ୍ଟଟା ଯୋଉଥିପାଇଁ ଆପଣ ପଚାର ନାହାନ୍ତି ଆକୁଳି ସ୍ୱାଇଁର ଷ୍ଟେଟମେଣ୍ଟଟା ବାହାର କଲ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ବିଷୟରେ ବୋଧେ କହିଛି କେସ୍ ଡାଏରୀ ବାହାର କଲ ଦିସ୍ ନେମ୍ ଇଜ ଆକୁଳି ସ୍ୱାଇଁ ସେଗୁଡା ମୋର ନାମ ଆକୁଳି ସ୍ୱାଇଁ ମୋର ଦେବାର ବୟାନ ଉଠିଛି ଗତ 5/6/2003 ଦିନ ପ୍ରାୟ 9ଟା ବେଳେ ମୁଁ ମୋର କାମରେ ଜରକା ବଜାର ଯାଉଥିଲି ଜରକା ବଜାରରେ ଗିରିମଣ୍ଡଳ ସୁଆଂଶକୁ ଯିଏକି ଜରକା ବଜାରରେ ବ୍ରଏଲର କୁକୁଡ଼ା ଫାର୍ମ କରି ରହୁଛି ମୋ ସାଙ୍ଗରେ ଦେଖା ହେଲା ଦୁଃଖ ସୁଖ ହେଉଥିବା ଅବସ୍ଥାରେ ମୋତେ କହିଲା ଆଜକୁ 7-8 ଦିନ ତଳେ ମୁଁ ଚାନ୍ଦକୁ ମାରି ମୋର ବାଟ ସଫା କରିଦେଇଛି ପୁଲିସ ପଚାରିଲେ ମାନିଯିବି ମୁଁ ତାକୁ ମାରିବାର କାରଣ ପଚାରିବାରୁ ସେ କହିଲା ଚାନ୍ଦ ବହୁତ ଖରାପ କାମ କଲା ମୋ କଥା ମାନିଲା ନାହିଁ ମୁଁ ରାଗରେ ମାରୁ ମାରୁ ମରିଗଲା ସେ କହିବା ଅନୁସାରେ ଆମ ଗ୍ରାମର ସୁଆଂଶୁ ମଧ୍ୟ ଥିଲା ସେ ମଧ୍ୟ ସୁସା ଇଜ ଦ୍ୟାଟ୍ PW4 ସେ ମଧ୍ୟ ଶୁଣିଛି ଗିରିମଣ୍ଡଳ ଠାରୁ ଏପଟ ଶୁଣିବା ପରେ so this statement is there extrajudicial confession is there in the 161 statement so that is but ये जो आप पचार देले ना
So taking tea and tea stall part is only not there.
that is not it. Question is extrajudicial confession टा ହେଇଛି କି ନାହିଁ extrajudicial confession in fact that is there so ये जोड़ा statement पचारले disclose that he had killed his wife you have not stated that is not a correct he has stated that only contradiction you are right that हे जो ସମୟଟା ଏଠି କହୁଛି 7 AM ସେଠି statement କହିଛି 9ଟା ବେଳେ ବାକି ଗୋଟେ ଚାହା ଦୋକାନରେ କହିଲା ବୋଲି ସେଇଟା କହିନି ଏଠି କହିଛି ଯେ ସେ ଜାରକା ବଜାରରେ ଦେଖା ହେଲା ଇଏ କିନ୍ତୁ ଇଏ ଥିଲା PW4 ଥିଲା ବୋଲି ସେ କହୁଛି ସୁସା ଯୋଉ କହୁନି ସୁସା ମଧ୍ୟ ଉପସ୍ଥିତ ଥିଲା ସୁସା ଇଜ ଦ୍ୟାଟ୍ PW4 ସୁରେଶ ଦୁଃଖ ସୁଖ ହଉଥିବା କହିଛି ଦୁଃଖ ସୁଖ ହେଉଥିବା ସମୟରେ ସେ କହିଲା ମୁଁ ଚାନ୍ଦକୁ ମାରି ବାଟ ସଫା କରିଦେଇଛି ପୁଲିସ କହିଲେ ମାନିଯିବି ଶୁଣୁଛି ଏତେ ସକାଳୁ କାହିଁକି so how do you get over this type of evidence go one by one
My lord.
one that you were in the company of the deceased who is none else than your wife. Right? Children, one of the child has been examined. He has also stated that ଆମେ ଏକାଠି ରହୁଥିଲୁ ଏବଂ is an eyewitness ଛାତିକୁ ମାରିଲା. It is corroborated by the medical evidence. Next circumstance, after your arrest, you lead to the discovery of that place where it was dogged out, that dead body was found in a decomposed state it was found. And that evidence has been adduced by PW3 and the IO. Next is your extrajudicial confession before two witnesses. So little discrepancy is there about the timing. Otherwise, so far as the extrajudicial confession part is concerned, ମାନେ ସେଇ ପାର୍ଟଟା 3 ଆଉ 4 4 ଆଉ 5 ୟା ଭିତରେ କନସିଷ୍ଟେନ୍ସି ଅଛି except that 7ଟା ବେଳେ କହିଲା କି 9ଟା ବେଳେ କହିଲା ଏଇ ୟା ଛଡା ବାକି ଆଉ ସବୁ ଇଏ କହୁଛି ଯେ 7:30 ରୁ 8ଟା ଭିତରେ ଆଉ PW5 କହୁଛି 7ଟା ବେଳେ. Otherwise main part and you have failed to elicit anything from the child that she has been tutored to depose falsehood against his father, her father. So merely because she was staying in the company of her grandparents and which she obviously be because mother died, father has been taken into custody, so obviously she will stay in the company of her grandparents. ତେଣୁ ଆଉ ତ କେହି ନାହାନ୍ତି ୟାଙ୍କର ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ଥାନ୍ତେ ପୁଅର ଅଲଗା କଥା ତେଣୁ ଏ ସର୍କମଷ୍ଟାନ୍ସରେ
ଫ୍ୟାମିଲି ତା ଭାଇ ଅଛି ନା ଭାଇ ନାଁଟା ବି ଏତଲାରେ ଦେଇଥିଲେ
ଗ୍ରାଣ୍ଡ ପ୍ୟାରେଣ୍ଟସଙ୍କ ପାଖରେ ରହିଲେ ସେମାନେ ଯେ ଶିଖେଇ ଦେବେ ଏଇ ଯୋଉ ଜିନିଷଟା କହୁଛନ୍ତି this is an hypothetical one unless because you have put the questions and the witness has answered that no I have not been tutored by nothing has been brought out in that respect. So there is no general proposition that the witness, if he stays with so and so, he will depose against her father. So, and in the state of mind of a child who is just aged about 8 years, when she deposed, she said her age to be 10 years, but when the occurrence took place, she was just 8 years of age. And when she had seen all these things, what kind of psychological impact would be there on that child? ତେଣୁ ସିଏ ଆଉ କାହାକୁ କହିନଥିଲା ପୋଲିସ ପାଖରେ କହୁଥିଲା ସେ ଯୋଉ ଫିୟର ସାଇକୋସିସ୍ ତାର ରହିଥିବ ଏଗୁଡାକ we cannot lost sight of all these things. So particularly when the main thing is that when your wife was staying in your company and her dead body was found in the backside of the house in a buried condition, so it is within your special knowledge how if your case is that your wife is missing then you should have been the first person to report the matter ଯେ ମୋ ସ୍ତ୍ରୀଟା ଡେଡ୍ ବଡି ତାର କେବେ ହେଲାଣି 7-8 ଦିନ ପୂର୍ବରୁ ମାନେ 7-8 ଦିନ ହେଲାଣି ଆପଣଙ୍କର ୱାଇଫ ଆପଣଙ୍କ ପାଖରେ ନାହିଁ ତ you should have been the first person ମୋ ସ୍ତ୍ରୀ କୁଆଡେ ଗଲା your conduct in not reporting the matter to the police bringing it to ଆରେ ପଳେଇଲା କି ବାପ ଘରକୁ ଆଉ ଛୋଟ ଛୋଟ ଛୁଆ ଦିଟା ଅଛନ୍ତି ତ ଏଇ ଯୋଉ କଣ୍ଡକ୍ଟଟା ଏଇଟା ଆହୁରି ଗୋଟେ another feature which shows that you are perhaps the author of the crime and ତେଣୁ ଆପଣଙ୍କର ଏଇଟା ଯଦି ଏକ୍ସକ୍ଲୁସିଭ ନଲେଜ ହେଲା ଆପଣ ଖାଲି ନେଇଛନ୍ତି ପ୍ଲି ନା 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 କହିଦେଇଛନ୍ତି ମିଛ କଥା
ନାଇଁ
କିଛି କୌଣସି
ନା 313 ରେ କହିଛି ଯେ ମୋର 498 କେସ୍ ଥିଲା ମୋ ସ୍ତ୍ରୀ ତାଙ୍କ ଘରେ ଯାଇ ରହୁଥିଲା 313 ଲାଷ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ରେ ପେଜ 47 ରେ
ସେଇଟା ରହୁଥିଲା ସେଇଟା କଣ ଝିଅ କହିନି କି
ହଁ ଝିଅ ବି କହୁଛି
ସିଏ
ସେ
କହିଛି
ତା ବାପା ଘର
ତାପରେ କିଛି ଦିନ ଆଗରୁ ଘଟଣାର
ସେଇଟା କେହି କହୁନାହାନ୍ତି ଯେ ଘଟଣା କିଛି ଦିନ ପୂର୍ବରୁ ଆସିଥିଲା ବୋଲିକା
କୋଉଟା
ଘଟଣା କିଛି ଦିନ ପୂର୍ବରୁ ସେ ଆସିଥିଲା ବୋଲି କେହି କହୁନାହାନ୍ତି
No, that is there in this.
ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ବି
ଆପଣ ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ ର ପାର୍ଟ ଟାକୁ ନେଇ ଆସିଲେ
ଆଜ୍ଞା
ଆପଣ ଆଣିଲେ କଣ ନା ସେ ଯାଇ ରହୁଥିଲା ସେଠି ତା ପର ଲାଇନ ରେ ଅଛି ଯେ ଘଟଣାର କିଛି ଦିନ ପୂର୍ବରୁ ଆସିକି ରହୁଥିଲା ସେ ପାର୍ଟ ଟା ଆଣିଲେନି
ଆଜ୍ଞା
ତେଣୁ ତା ମାନେ ନୁହେଁ ଯେ ସେ ଯାଇକିନି ପୁରା ରହୁଥିଲା that part is there and more particularly the witness has stated that we are living together at that point of time ଯୋଉ ଛୋଟ ଛୁଆଟା ସେ କଣ କହିଲା
ସେ କହିଲା
କୋଉଟା obviously you no see obviously she would go there where she will go the child there are two children ଆଉ ତ କେହି ନାହାନ୍ତି ନା ବାପା ମା ମରିଗଲେ ବାପା ଜେଲରେ ମା ମରିଗଲାଣି ତେଣୁ ଆଉ ତାଙ୍କୁ କୋଉଠି ରହିବ ସେ ଇଏ ଯାଇକିନି ବୁଝାବୁଝି କରୁଥିଲେ ସେଠି ତ ରହୁଥିଲା ସେ ହଁ ସେ ତ ସେଠି ରହୁଥିଲା ଆଉ ରହିବ କୋଉଠି ରହିବ my grandfather and my grandmother never tutored me very positive statement to speak out the so and so I have not told about the Gondover so it is to be brought on record the law is that merely that they are prone to tutoring children are prone to tutoring ତାଙ୍କୁ ଗୋଟେ ଶିଖେଇ ଦେଲେ ସେମାନେ କହିଦେବେ ଯେ ସେମାନଙ୍କର but something must be brought out on record in that respect ଏଠି ଗୋଟେ ଛୁଆ ତାର ସେ ମନା କରୁଛି ମତେ କେହି ଶିଖେଇ ନାହାନ୍ତି ହେଲା ତେଣୁ ମୋ ଅଜା ଆଈ ମତେ ଏ ବିଷୟରେ କହିନାହାନ୍ତି ବାକି এই পার্টটা যদি কହୁଛି এবং this is corroborated by the medical evidence that is another aspect छाती की जो मारला ଏବଂ ସେ ଛୁଆଟାକୁ କହିଛି ବାପା ଇଏ କଣ କହିଛି ଯେ ମୁଁ ତାକୁ ଶୋଇବା ପାଇଁ ଇଞ୍ଜେକ୍ସନ ଦେଇଛି ଆଉ ସେ ଶୋଇଛି ସେ ବି ଦେଖିଲେ ମାନେ ଛୁଆ ଗୁଡାକ ଯେ ମା ଶୋଇଛି 2 days after my father carried the dead body of my mother to the backside of the house and buried under Swanson. At that time we are residing at Swanson. This witness has also seen that carrying of the dead body. Prior to the incident, there was gondogol between my father and my mother. My mother was going to her father's house, and at that time I was staying with my father. So the evidence has come that you are staying with the deceased, so also your children. One of your daughter has seen you assaulting the deceased, and telling her after the assault that he has administered sleeping injection to her. Then she has also seen carrying the dead body. Then the dead body was recovered from your backyard, which was in your possession. That was in a decomposed state. On the basis of your statement recorded under section 27, that dead body was sent for PM examination, and injuries were found on the chest, which is also the version of the witness, that is PW2. Then extrajudicial confession before 2 witnesses. So all these things, and no explanation, nothing except that ଗୋଟେ 498 केस ହେଇଥିଲା, ସେ ଯାଇ ସେଠି ରହୁଥିଲା, ଯଦି ତାର ଡେଥ୍ କେମିତି ହେଲା, ଆଉ ସେ ଡେଡ୍ ବଡି କାହିଁକି ଆସିକି କେମିତି ଆପଣଙ୍କ ଇଏରେ କେମିତି ପୋତା ହେଲା, ଆଉ how do you get over the witness evidence that it was recovered from your backyard? Spot map is also very clear. Evidence of the witnesses is also very clear. एटा आपण कंपाउंड भितरे आपणकर कंपाउंड देखुछन तो जो गारटा होची आपणर कंपाउंड ता देहरे से जो डीच रे पोता आइता सेटा को सेटू बाहर कराई छी.
Also, blood-stained earth has been recovered from the room of the accused and the deceased, Your Lordship. I only have the forwarding report, Lordship. In my paper book, it is the
ग्रुपिंग
chemical
पे पठाई
examination
ग्रुपिंग
report
है
is
नहीं
not there.
से ह्यूमन ब्लड भी कोन सेटा ग्रुपिंग पे पठाई तला सेति का भी छै नहीं ग्रुपिंग अरे यार ब्रॉयलर शॉट ला जे कुकुडा रे रक्त ही
Bloodstained earth sample earth collect ହେଇची from the bedroom, and it was forwarded to the for
this
C
directors
examination. That report has not been proved.
no
Not there.
not as
So even if we skip it, let us say that there was no such thing, that it was whether it was human blood or not, but yes, anything else you want to?
only my lord the PW2 is the child witness my lord. The court below has not put rational answers questionnaire format in technically I am stating how to he understand the language of the court.
No, some questions have been put,
but that should be in questionnaire format my lord. सेटा करा ही नहीं.
No.
The court understand my lord how the child will be understand the language of the court my lord. That was not put.
What was the question and what
was
was
the answer my lord. That should be in questionnaire format my lord.
No, questions have been put, but what was
how far she understand the language my lord, how far she understand the language.
But there are decisions to the effect that even if the questions and answer have not been mentioned in their deposition sheet, but the court has recorded its satisfaction, and the manner in which the child has answered to different questions put by the public prosecutor, so also the defense counsel, shows that he has capacity to understand the questions and answer it. That would show that he was a competent witness. These are all technicalities.
Yes, madam. I am taking that
Jadi-
delay in examination of the witness by the IO.
Uh-huh.
Delay in examination of the 161 statement recorded at the 8 and 10 days after the incident, after the recovery of the dead body.
ଆଉ କେବେ recover ହବ?
Dead body recover 8-10 दिन ପରେ ସେ ଝିଅକୁ ନେଇକି ସେ ଯାଇକିନା ଥାନାରେ ତା ଗ୍ରାଣ୍ଡଫାଦର ନେଇକି ଏକ୍ସାମିନେସନ ଇନ୍ ପ୍ରେଜେନ୍ସ ଅଫ ଦି ଗ୍ରାଣ୍ଡଫାଦର, ସେଇଟା ବି ଗୋଟେ ପଏଣ୍ଟ।
Just a minute. Dead body that ଏଇ ସାର statement ଟା ବାହାର କଲା ସେ ଝିଅଟାର, ଯେ ଛୋଟ ଝିଅଟା। ଆଶା ତ?
ଆଜ୍ଞା ଆଶା ମଣ୍ଡଳ।
ଆଶା ଆପଣଙ୍କର ଏଫଆଇଆର ହେଇଛି 5/6/2003।
ଆଜ୍ଞା।
ଆଶା ମଣ୍ଡଳର ଷ୍ଟେଟମେଣ୍ଟ ହେଇଛି 5/6/2003 ରେ। ଆଉ କଣ 7-8 ଦିନ ପରେ କେମିତି ହେଲା?
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛି କିନ୍ତୁ 8 to 10 days after the occurrence I was examined by the police।
ଆରେ ଅକରେନ୍ସ ପରେ ପରେ ତାକୁ ନେଇକି ପୋତା ହେଲା, ପୋତା ଡେଡ୍ ବଡିଟା ମିଳିଲା 6-7 ଦିନ ପରେ, ହେଲାନି ଏକା କଥା। ଏଫଆଇଆର ଯେପର୍ଯ୍ୟନ୍ତ ଏଫଆଇଆର ନ ହେଇଛି, ପୋଲିସ ଇନଭେଷ୍ଟିଗେସନ ତ ଆସିନି, ସେ ଏକ୍ସାମିନ ହବ କେମିତି? ତେଣୁ 5 ତାରିଖ ଦିନ ଏଫଆଇଆର ହେଇଛି, 5 ତାରିଖ ଦିନ ହିଁ ତାକୁ ଏକ୍ସାମିନ ହେଇଛି। ଆଉ ଡିଲେ କୋଉଠି ହେଲା? ହଁ, କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହବା ପରେ 6-7 ଦିନ ଡିଲେ, ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। Yes. Any other point?
Extra, my lord, the Schedule 4 and 5, my lord. The extrajudicial confession, my lord.
Yes.
My lord, Schedule 4 stated that he was not examined by the police, my lord. In the first time, my lord, he has deposed before the court in trial, my lord. See, I was not examined by the police.
But the statement is available and no such question has been put to the IO. This come to PW4 you are telling?
My lord.
Again, on that point, the decisions are that merely because a witness says that I have not been examined, by police would not be sufficient unless you put that question to the IO. Number two, when the statement is very much available on the case record. So here no question has been put and the statement is very much there. And in addition to that, PW5 has also stated about the extrajudicial confession. It's not
Five is my lord, 5 is the neighbor of the informant. Five is the immediate neighbor of the informant. So he supported the my lord. He might be biased by the informant.
Hypothetically, प्रश्न गुड़ाक सबमिशन कले कौन हम आपण क्रॉस एग्जामिनेशन रे जहाँ कहिसेंती जे
And see, PW5 stated that the house of PW3 Sheikh Asamuddin is at a distance of 300 feet interval by 3 houses from my house. I was examined by police 5 to 6 days after the accused disclosed the fact before us. 5-6 दिन ପରେ accused disclose कला.
ଏବଂ PW4 ର ପ୍ରେଜେନ୍ସ PW5 କହୁଛି ଯେତେବେଳେ କନଫେସନ ହେଲା ସେ କହୁଛି ଯେ PW4 ପ୍ରେଜେଣ୍ଟ ଥିଲା ବୋଲି
The PW4 কিন্তু କହୁ ନାହିଁ ସେ କହୁଛି none of the people present there detained him by for going to the PS. 10 to 12 persons were present when the accused told about the incident before us.
Okay, anything else?
Extrajudicial confession, my lord, there is a decision I have gone through, my lord. Exact version of the accused should be tell before the court, my lord. Exact version. That is called extra version, my lord. See, they have stated that he has come and he stated that he killed his wife, my lord. So exact version of the accused should be tell before the trial court, my lord. That should be considered. What he has stated in presence of the ସେ କହିଲା ମୁଁ ସଫା କରିଦେବି ତା ସଫା କରିଦେଇଛି କିନ୍ତୁ ଇଏ କହୁଛନ୍ତି ସେ କହିଲା ମାରି ଦେଇଛି ବୋଲି କହିଲେ କୋର୍ଟରେ କହୁଛନ୍ତି he killed his wife. ସେ ଏକ୍ସାକ୍ଟ ଭର୍ସନ ଟା ନାହିଁ.
ଏକ୍ସାକ୍ଟ ଭର୍ସନ କଣ ବା କହୁଛି ଯେ 4 ନମ୍ବର ଆସିଲା he disclosed before us that he has killed his wife. Number 1. Again PW5 accused said that he has killed his wife. ଆଉ କଣ ଆପଣଙ୍କୁ ଏକ୍ସାକ୍ଟ ଭର୍ସନ କଣ କଣ ସେ ମାନେ କମ୍ପ୍ୟୁଟର ରେକର୍ଡିଂ କରି ରଖିଥାନ୍ତେ ସେ କହିଲା ଯେ ମୁଁ ମୋ ସ୍ତ୍ରୀ କୁ ମାରି ଦେଇଛି ଏ ବିଷୟରେ ଇଏ କଲା ଆଉ ଏକ୍ସାକ୍ଟ ୱାର୍ଡ କଣ मेन क्रीम ऑफ दी जिंस सेटा देखिया पड़िबो जे कंसिस्टेंट कि नाही
मोर एतिक माय हम्बल समझ एतिक तो एतिक पेपर पाई आसे 13 वर्ष 3 मास रही कि जेल पीरियड ऑफ डिटेंशन है हाई कोर्ट
नो इट कैन नॉट बी वंस इट इज फाउंड गिल्टी मींस there cannot be any alternate sentence the manner in which it's not a case that the grave and sudden provocation eichi kon eichi je taku ଆପଣ ରିଡ୍ୟୁସ କରିବେ 304 ପାର୍ଟ 2 କି ପାର୍ଟ 1
କିଏ ବି କହୁଛି ମାନେ ଯାତ୍ରା ଦେଖି ଆଇଲା ପରେ ସେ ଜଣ ସାথে ଦେଖିଲା ପରେ ଗଣ୍ଡଗୋଳ ହେଇଛି ତ ସେଟା 304
the manner in which the crime has been committed the false kind of false statement has been made then cunningly the dead body was buried
କହୁଛି ଗଣ୍ଡଗୋଳ ହେଲା ପରେ ମାରିଛନ୍ତି ସଡନ ପ୍ରୋଭୋକେସନ ସେ ଯାତ୍ରା ଦେଖି ଫେରିଲା ବେଳେ ଆଉ ଜଣ ସାথେ ଦେଖିଲା ପରେ କହୁଛି ଗଣ୍ଡଗୋଳ ହେଲା ମାଇଲେ ତା ଦେର ଯେ ଗଣ୍ଡଗୋଳ ସେଇ ରୋଲ 2 ବି କହୁଛି ଗଣ୍ଡଗୋଳ ହେଲା ପରେ ମାଇଲେ ଇନ କୋର୍ସ ଅଫ ଗଣ୍ଡଗୋଳ
ତାକୁ ନେଇ ପଛପଟେ ପୋତି ଚୁପଚାପ ରହି କାହାକୁ ନ ଜଣେଇ ତାପରେ ସେମାନେ ଆସିଲେ ସନ୍ଦେହ ହେଲା then you are arrested and then
Of course, one witness has stated during cross-examination that he was behaving like a madman.
There is no such plea or no evidence. But everything has been done in a very cunningly that shows that he is a very sound person, mentally sound person. Yes, my wife. Yes, killed his wife, so and so.
He's going to surrender before the
Right, right.
police.
Surrender Poland, but subsequent.
Intention of killing, put his option in the
ଛୁଆର ଏଭିଡେନ୍ସ ହଉଛି ମା ଯେତେବେଳେ ମାଡ ଖାଇଲା ସେତେବେଳେ ମା ତାକୁ କହିଲା ପାଣି ଦବା ପାଇଁ, ଇଏ ତାକୁ ମନା କଲା। ତାପରେ ମା ତାକୁ ବାରମ୍ବାର ହଁ ମା ବାରମ୍ବାର ପାଣି ପିଇବା ପାଇଁ ମାଗିଲା ପରେ ଯେହେତୁ ଇଏ ନଦେଲା ବା ମନା କଲା, ମା ମରିଗଲା। ଡେଡ୍ ବଡି ଅଫ ସ୍ୱାଂଶୁ ସେଇ ରୁମ ରେ ପଡିଥିଲା ଫର 2 days। ଇଏ କହିଲା ତାଙ୍କୁ ଇଞ୍ଜେକ୍ସନ ଦେଇ, ସେମ୍ ଷ୍ଟେଟମେଣ୍ଟ ଇଜ ଦେୟାର। ସେଟା ବାହାର କଲା ଇଞ୍ଜେକ୍ସନ ଟା ନାହିଁ, ବଟ୍ ଏଇଟା ଯୋଉ ପାଣି କଥାଟା ଅଛି। ହଁ ସେଇ ଯୋଉ ଝିଅଟାର ଷ୍ଟେଟମେଣ୍ଟ ଟା ବାହାର କଲ, କଣ ତା ନା ଆଶା। ଘରେ ପହଞ୍ଚି ବାପା ବୋଉଙ୍କ ସାଙ୍ଗରେ କଳି କଲେ। ଆମ 2 ଭଉଣୀଙ୍କୁ ବାଡେଇଲେ। 2 ଭଉଣୀ ଶୋଇଲୁ, ମତେ ନିଦ ଲାଗୁନଥାଏ। ବାପା ଗୋଟେ ମୋଟା ବାଡିରେ ବୋଉକୁ ଖୁବ୍ ଜୋରେ ବାଡେଇଲା। ମା ମାଡ ଖାଇ ତଳେ ପଡିଗଲା, ପାଣି ମାଗିଲା। ବାପା କହିଲେ କେହି ପାଣି ଦେବେ ନାହିଁ। ତାପରେ ପୁଣି ମାକୁ ମାରିଲା। ମାର ଚେତା ବୁଡିଗଲା, ଆଉ ପାଟି ନ କରି ଶୋଇ ପଡିଲା। ସେଇ ଘରେ ମାକୁ ଘୋଡାଇ ରଖିଲା। ସକାଳୁ ଉଠିବାରୁ ସେ ଘରକୁ ଛାଡିଲା ନାହିଁ। ବାପା କହିଲେ ତୋ ବୋଉ ବ୍ରହ୍ମବରଦା ଆଉ ଯାଜପୁର ଯାଇଛି। ତାପରେ ଆମେ ସେ ଘରକୁ ଗଲି, ଦେଖିଲୁ ବୋଉ ନାହିଁ। ଯେତେବେଳେ ନେଇ ଡେଡ୍ ବଡିଟା ପରେଟ୍ ହେଇଯାଇଛି। ମୋର ବାପା ଆଜି ପର୍ଯ୍ୟନ୍ତ How do you, yes, Mr. Mishra, what do you say?
Lordship. Lords, my prime submission is PW2 only, Lords, the child witness, because her witness is completely corroborated by the medical evidence, Your Lordship, what she had stated. Because the
Oral evidence of PW2,
my Lords,
getting corroboration from PM doctor, that is
PW1,
PW1.
my Lords. Because the version of PW2 is that the accused was assaulting with a lathi on her chest, Your Lordship.
Right.
And my Lords,
the doctor has stated,
Lordship, there was fracture of 5th, 6th, 7th, and 8th ribs, my Lords. 4 ribs were completely fractured.
Eta halla. Where is that fracture was?
Page 49, Your Lordship, the first paragraph.
There was fracture of 5th, 6th, 7th, and 8th ribs anteriorly on the right side. Okay. And there was also there was a fracture of left wrist joint.
Lordship.
And so on. So okay.
So that she could have sustained while defending herself.
While falling down.
Tapare then she କହୁଛି ଯେ mode of death କେମିତି ମଲା ନା ଯୋଉ extensive chest injury ହୋଇଛି ଯୋଉଟା କି antemortem in nature ଏବଂ that is 7 to 10 days.
So this is in complete corroboration with the eyewitness, Your Lordship. And also PW's 2 version has not been shattered by the cross at all, Your Lordship. And Your Lordship, PW 4 and 5, even though PW 4 has not been examined by the police, because I don't have the copies of the 161 statements.
That is there. 161 is there.
Lordship. So even if he was not been examined under section 118, there is no such limitation that his witness cannot be taken into account, my lords. And PW 4 and 5, both the both the witnesses to the extrajudicial confession has also corroborated each other, my lords. Because PW 5 has stated that PW 4 was there, and it is quite natural that PW 4 was there because he is the beetle shop owner.
One is beetle shop, the other is tea
Tea
stall.
stall, my lords.
Okay.
Now, my lords, so far as the leading to discovery part is concerned, even though 2 of the independent witnesses have turned hostile, but still there is corroboration from the
PW3 and the IO.
IO, my lords. So therefore, it leaves no doubt that in fact it was the accused who had indicated the spot, and on the indication of the accused only, the dead body was dug out, my lords.
And it was such a place that where
Lordship.
other person cannot have
knowledge.
the knowledge that
My
it
lord.
was. So it was within the exclusive knowledge of that.
Lordship.
See, khali say question re kon answer diji micho.
Only one statement here stated, Lordship.
No, accused statement.
Yes, that's a
Tame nekin police ko emti jaga dekhei delo.
Yes, Lordship. This is micho kochi.
Micho batabe.
That is question number 8, Your Lordship, at page 45.
We transfer from the evidence of the IO and the witness that the dead body of your wife was recovered from the place pointed out by you after digging. So answer is Micho.
Micho, Lordship.
8 number question.
And so far as my learned friend's submission about tutoring, my lords, that is not at all based on any evidence, rather only presumptions, Your Lordship. So that cannot be taken into account at all at the appellate stage right now, my lords.
All right, since today there is no time, we'll dictate the judgment tomorrow.
Lordship.
We find both of you find any decision, you can cite tomorrow. Okay?
My lord.
Thereafter,
My lord.
list कर दो
Juvenile bail matter.
Give it.
One criminal appeal matter. Appellant convicted under jail criminal appeal. To accused persons have been granted bail by your lordship. Appellant convicted 10 years. Out of 10 years, he was a custody since 8 years.
Give it.
Another is tied up matter.
In this appeal, my lord, also had the matter November, my lord, and directed the jail author to custody date, my lord. Custody is already come, my lord. Out of
bail petitions last was on 8th. These petitions were posted last on 8th.
What is the matter?
Bail matters.
With my third mention for vacation, I made a mention that is the interim release of my passport because my contract with the foreign university has already been expired. And besides that, my daughter-in-law has given birth to a child whose namkaran is still illegal. So I have to travel for 15 days to have that has been rejected by the learned CBI.
You give it.
Let it be.
We'll see that.
My contract with the university has been expired. So I pray, my lord, your lordship said that it will be taken up after vacation.
Okay, yes.
My lord, one bail application, it was directed to be listed on 16/1, but till date not listed.
Give it.
16/1/2000.
Lordship, then your conviction, but 5 years already gone.
Give it.
This is a bail.
Another extension for time. I file extension of time.
Okay, yes.
This bail matter specific as on 29.
Sure.
May I pardon to mention, my item 48.
Wait. Yes?
Yes, sir.
Give it.
Vigilance matter, petition challenge against the charge made.
Revision petition.
Right.
All right, just give it.
Sir, my lord, your lordship has pleased to grant interim bail. So it was adjourned to 8/1/2024.
Give it.
Other matter, it's a limit for limitation matter. This is a revision petition matter. Limitation ପାଇଁ ଥିଲା.
Revision for what purpose? Why you are...
PID matter.
Okay. Discharge petition rejected. Or give it. Yes.
Item 48. The father has expired and tomorrow is the rituals, my lord. Your lordship. On Friday, my lord and senior has 48, na? 40. We taken up.
What is that IA number?
IA number 256 of 2024.
Petition number 1.
Again.
Petition number 1. All right, IA number 256 of 2024. This is an application for interim bail of petitioner appellant number 1, Kusu Murmu, on the ground that his father has expired on 21/4/2024, and in order to perform the obsequies ceremony, his presence is very much necessary.
24/1.
24,
No, 24.
24/1/24.
Yes, sir.
The Learning Council for the state has obtained instruction from IIC Sadar Police Station, Baripada, Mayurbhanj, which is dated 2/2/2024, from which it appears that the father of the appellant number 1 is no more. The written instruction is taken on record, considering the submission made by the Land Council for the respective parties, averments taken in the interim application, and the written instruction produced. I am inclined to release the appellant number 1, Kusu Murmu, on bail for a period of 2 weeks from the date of release. Urgent certified copy.
Obliged.
I want to mention item 33.
Posted the matter after he will file the surrender certificate.
Obliged.
So this is item number
48.
48. Okay.
There is a noting relating to other court. Said I have filed the surrender certificate already.
Land Council for the appellant submits the order. I खाली main tar लिखी. That surrender certificate of kahar file करछेंगे.
Appellant number 2.
Appellant number 2 has already been filed. Registry shall place the same on record. Yes.
Item 33 minutes.
Yes.
Item 33.
33? Yes.
So 2000 लोक अरेस्ट ହେଇଥିଲେ ରିଲିଜ ହେଲେଣି ଏଇ ଗୋଟେ ପିଟିସନର ରଙ୍ଗଲି ଆରେଷ୍ଟ ହେଇକି ଅଛି ସେ ଭିତରେ 4-5 ଥର ବି ଡେଟ୍ ହେଇଗଲା
କଣ ବୁଝିପାରୁନି କଣ କହୁଛନ୍ତି?
in this case 2000 people has been released on the bail the group case in the Ganjam district of
What do you want?
2011
Why are you mentioning the matter? I'll take up this matter serially. Why are you mentioning it? It's a case that was an exceptional case. Father died. Tomorrow is the 11th day. Yes.
My lord, I'm on BC, my lords.
Yes.
My lord, CRLA 79 of 2024.
Yes.
It's a conviction matter, my lord. The petitioner was in custody, vigilance matter. May I plead tomorrow, my lords?
Get
4
it.
years conviction.
All right. All right. Huh?
CRLA 79.
Yes.
Quickly list item number 1.
May be permitted to place this matter on behalf of Swaraj Patel, my lord. The appellant was convicted for the offence under section 13(2) read with section 13(1)(d) along with section 7 of the PC Act and sentenced to RI for 3 years and 2 years respectively, as well as fine to pay fine of rupees 3,000 and 2,000, my lord. At page number 75, the judgment.
So the maximum sentence is 2 years.
2 years, my lord.
And you are on bail during trial.
Yes, my lord.
Yes, Mr.
Just now I received from my learned friend, the copy was served on them.
Yeah.
And I will file my
All right.
appearance memo by the end of April, my lord.
And Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department. Admit he was on bail, bail granted, stay realization of fine. Free copy of the order be handed over. Name of the Mr. Das be reflected in the cause list. Yes.
Item number 2.
May I please, your lordship? My lord, it's an
May I please, your lordship? Your lordship, the appellant is convicted under section 376(3), 376(2)(n), read with section 6 of POCSO Act. RI for 20 years and fine of rupees 10,000, and in default RI of 6 months for offence under section 376(3).
Okay, same order. Admit extra copy to be served. 376(3) is there. In both these matters, there is no bail application. But notice. Yes.
Obliged.
Item number 5.
May I please, my lord, page 39 of the under section 307 IPC for the impeachment for 10 years, regulation impeachment 10 years, and with fine 20,000. And also convicted section 394 IPC, and that fine also 20,000. And other offenses 25 1BA arms act, and the impeachment
So
for
it's a 10-year sentence.
yes, concurrently
All
10
right.
years. Sir.
Admit call for the trial court record, interim applications for bail and stay realization to be considered after receipt of the trial court record. Deposition copies to be supplied to the Land and Council for the state. Yes.
Problem.
Item 7.
Conviction is under section 7 and 13(2) of the PCI. The sentencing portion is at running page 52. Where is it? It is 2 years. Running page 52, internal page 37 of the.
Yeah, 2 years. Yes, Mr. Das.
Yes, my lord, I have received only sentence has been only under section 13(2) read with 13D, 1D. No separate sentence has been given under section 7.
Mr. Gautam Misra and senior advocate admit he was on bail granted, stay realization of fine. So far as IA number 223 of 2024 is concerned, Mr. Sanjay Kumar Das, Learning Standing Counsel for the Vigilance Department, submit that he will file objection
6 weeks time.
to the interim application, and 6 weeks time may be granted. Put up this matter, give a date in March, and objection, if any, be filed in the meantime, giving copy to the Learning Council for the appellant. Yes.
Stay of conviction 223. There we have served copies of the depositions already on my.
It is stated by Mr. Mishra that copy of deposition has already been set. I stay of conviction. All right.
I may be pardoned, my lord. Item number 1,
Yes.
in the cause list, it may be reflected as vigilance.
Acha. Item number 1 day after state of Orissa, in bracket it will be mentioned as vigilance. Okay.
Probably. A free copy be granted this item 7.
All right.
The appellant is in service still now. So 6 weeks he is wanting. So maybe
No, there are several applications for a stay of objection. So many applications.
Shorter date is all that I pray.
We are fixing it May, March. So it will, you see it in the evening hours. What is the date? Okay? Yes.
Great.
Item number 8.
May I please? The appellant has been convicted under section 13(1)D, 13(2), and section 7 of the PC Act, my lord, and sentenced to undergo RI for 4 years. For 13(2) read with 13(1)D, and RI for 3 years under section 7 of the PC Act.
It's concurrent sentence.
Yes, concurrent. That is
And,
the relevant page, Lordship may kindly peruse. That is 62-63.
You were on bail during.
Yes, yes. Now I am in custody since the date of.
Mr. Das.
It is CBI, my lord.
Mr. Naik, you have received the copy?
Yes, Your Lordship, I have received.
Okay. Or Mr. Sarthak Naik, Learned Special Public Prosecutor. Admit he was on bail granted. sterilization of fine. Yes.
It's a free copy of the order.
Free copy of the order. Yes.
Item number 9.
Nine made please your lordships, my lord. There are two items. I'm in the second sub item, my lord. CRS 789.
Yeah.
Yes, my lords. I'm
May I pray, my lord?
Yeah.
As per the last order, my lord, there are two witnesses to be examined, my lord. As per my lord's direction, one has already examined. They have solved the deposition copy, my lord.
Bashanti Naik and Rajeshwari Naik.
Rajeshwari has been examined. They have solved the copy.
Okay.
But so far, their instruction is that Basanti has not been examined.
Basanti has not been examined. That's my instructions is, my lord. She has been receiving summons from the court, but she is not appearing. And now, in the meantime, she also left the village. Now, I am giving the deposition copy of, my lords, the informant, the Rajeshwari Naik. Just, your lordships may kindly see, my lords, what she has stated. Otherwise, if your lordships feels,
He has not supported the prosecution.
not supported, my lords, she says he fell down and your lordships may kindly see, my lords. I flag marked it, my lords.
Must have been declared hostile by the prosecution.
Again. Page 15 of that compendium.
Hostile. Why are you not producing that?
That's why let it be any other day. So
All right. As for the order dated 18/12/2023, though in the meantime, Rajeshwari Naik, who is the informant in the case, has been examined in the trial court as PW8, and she has not supported the prosecution case. London Counsel for the appellant submits that in spite of repeated summons issued to the only left out eyewitness, that is Bashanti Naik, is not coming forward to give her evidence, and he has instruction that the whereabouts of the said eyewitness is not known. Land Counsel for the state seeks some time to enable the IIC to appear before the concerned court, receive summons, and ensure the attendance of the eyewitness Basanti Naik. The evidence copy of the witnesses filed by the London Counsel for the appellant with a memo is taken on record. In view of the submission made by the Land Counsel for the state, let the inspector in charge of
Basanti.
which police station? Kodola. Kodola police station appear before the London trial court, that is Special Judge Kali Court, in Special GR case number 9 of 2021 bracket A, on or before 13th of February 2024, receive summons in respect of witness Bashanti Naik and ensure her attendance on the date fixed. Are you aware what is the date fixed?
Not present, I am not.
Mr. Sahu, are you aware?
The coming week,
Why don't you ascertain so that
just now.
give the date so that it can be examined? If they give the date, mention it, which is stated to be fixed on such and such date, and give a free copy to the state council and certified copy of the witness if examined to be produced. Basanti Naik. Yes. Put up this matter along with so and so. Dita ko ikatiya soon.
My lord, may keeping date if you.
It depends upon what is the date of that trial court. Just ascertain from the local council, give, so that we'll give another 1 week time. So that
We are trying to get.
Yes.
Number 10.
Yes, Mr. Das.
Yes, may I please, Lordship, my lord. Present
Mission of that witness, Gaurav Bogarty, eyewitness, has already been examined. I filed the copies of the deposition.
Gaurav Bagarti.
Yes, ma'am.
What he has stated?
Ton hostel.
How many witnesses have been examined so far?
Status report is there, ma'am. Your Lordship, in this present case, Your Lordship granted bail to one Sankirtan Gibhela. I have annexed his order, my lord, at Annex 3 series, my lord. CRL number 1213 of 2022. And thereafter, in that order at paragraph page 2, my lord, Your Lordship, my lord, note the name of the witness, that Gaurav Bogarty. And the present case, other, my lord, the accused persons also granted bail by the coordinate bench of this honorable court, my lord. I have also annexed those orders, my lord. CRLA 341 of 2021, 372 of 2020, 446 of 2020, and 447 of 2020.
When this Sankirtan Givela was released on bail, that is on 1/3/2023.
Yes, ma'am.
So the Krishna Vaira also released, my lord. Krishna Vaira and the present accused is same footing, my lord.
Krishna Varia was granted bail by the coordinate bench of this one. That order also I have annexed.
Are the learning counsel for the petitioner, learned counsel for the state? Appellant, learned counsel for the appellant submitted that the appellant is in judicial custody since
17/11/2022.
17/11/2022. And he has produced the deposition copy.
Noting is there.
So you witness deposition copy. PW केते से जो गौरव बगड़ती ना कौन कहले? हाँ दे दो. This is PW1.
It is a split up trial.
ये split up trial.
Again.
He has produced the deposition copy of Gaurav Bogarty, who has been examined as PW1, and he has not supported the prosecution case. आगो केसटा pending अछि ना चलीछि माने sorry the learned counsel further submits that the similarly situated co-accused persons who are facing trial in another ST case before the same court have already been granted bail, and therefore the bail application of the appellant may be favorably considered. Learned counsel for the state on verification of the case record submits that one co-accused Krishna Bariha has been granted bail by this court in CRLA number 447 of 2020 as per order dated 15/11/2022. A Krishna Bariha same putting though. And the appellant stands in the similar footing like the said co-accused. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, period of detention of the petitioner appellant in judicial custody, release of the co-accused persons on bail, I'm inclined to release the petitioner on Agura Astilegi bail. I'm inclined to release the appellant on bail allowed. এটা ডিপোজিশন কপিটাକୁ ରେକର୍ଡ ରଖିବେ
Item 12.
My Lordship, the petitioner in custody since 29
Yes.
Lordship. The Lordship, the appellant is inside the custody since 26/5/2020, Lordship. Lordship, the last present directive filed the deposition copies, Lordship. Lordship, kindly glance the PW7 in the present case, Lordship, and filing the deposition copy, Lordship.
You made a submission that material witnesses have been examined in the trial court.
Exactly, Lordship.
So,
It
have
is
you
the sec-
supplied deposition copy to the State
Lordship,
Council?
Lordship.
Yes, Mr. Tripathi, what the witnesses have stated?
Yes, they supported the eyewitness are there.
Who are the eyewitnesses?
PW1, 2.
No, just tell me one. One is an eyewitness.
One is the confessional statement.
Please tell me one eyewitness.
Eyewitness PW2.
PW2. Come to the evidence.
Sorry, PW3.
PW3 the informant, Lordship.
PW3 is the informant, so also the eyewitness,
Yes.
right?
No,
there are several eyewitnesses.
Please, one eyewitness.
1, 3, PW3.
Okay, please.
Para 3 Miller.
Yeah.
I, along with my brother Parameswar Chauhan, village ward member Tripti Suna, and others, about 20 persons, went to the spot and found that my father lying dead in the heart of the accused with bleeding injury on his face, back, on his head, and both the hands were tied with a dhoti. The accused was standing there holding an axe. On being asked, the accused replied, "Taku to marili, tamuku bhi maribi," saying this, chased us holding the axe. Out of fear, we left the spot.
So, in fact, this man reached almost immediately after the blows were given.
And a PW1 para 3. Getting such information, I, along with Sundar Haridan, Tirupati Suna, Dandidhar Jagat, Rimchan Chauhan, and others proceed to the spot and found the deceased was lying dead in front of the cottage with bleeding injury on his head, chest, mouth, and belly. On being asked, the accused who was present at the
So,
spot.
what is your submission? Repeated blows have been given on different parts of the body, including the vital part.
Lordship, kindly glance the PW3, the informant, Lordship, in paragraph 5, Lordship, in the chief, Lordship. Bhodeva Bagh.
Paragraph 5 is in the cross-examination.
Lordship, in chief, Lordship.
Yeah.
Bhodeva Bagh intimated the death of my father over phone to Rathahati of our village. Here, Lordship, the Bhodeva Bagh is the PW7, Lordship. Lordship, then kindly glance PW7, Lordship. PW7, Lordship. And the second para, Lordship, on the date of incident, one of my villagers came to me and stated me that a dead body was lying near the hut of the accused at Mosanipada. I went there and found that the dead body of Manichand Gond was lying there. There was bleeding from head and ear of the dead body.
So what is your submission?
Lordship, the witnesses are post-occurrence witnesses.
No,
the investigation.
this statement is that PW7, Buddha Bagh, he intimated to Rathahati. He does not say that it intimated to me.
Lordship.
You are right. He should have said that I got the information about the occurrence from PW7, and PW7 is a post-occurrence witness. Then obviously the PW3's version that the accused was present at the spot, I saw all these things, could not have been believed.
I'm coming to that point, Lordship.
Yes.
Here, Lordship, Bhodeva Bagh said on Rathahati, Lordship.
Yeah.
The informant got the information from the Rathahati, even if. Here, Lordship, the Rathahati is not the charge sheet witness in the case, Lordship.
Those are the things which are to be appreciated by the
in fact,
trial court.
it is a poor case.
Your
Lordship,
presence at the spot, extrajudicial confession.
4 years inside the custody.
Blows have been given. How many blows you have given, Mr. Tripathi?
Yes, Miller.
What is the post-mortem report? Weapon of offense is
Tangia, that is recovered at the instance of the accused.
Yes. What are the blows and what are the body parts?
There are 6 injury.
कौन cause of death कौन कହୁଛନ୍ତି?
Cause of death is craniocerebral injury and complication thereof.
Okay, 3-2B माने notice sufficient यही तो?
Yes, sir.
So you are in custody since when?
26/5/2020
And having 3 criminal antecedents.
26/5/20
2020
total witness केते हेलेनी?
18 witnesses on my instruction, 13 witnesses have been examined.
13.
Lordship.
Are the learned counsel for the petition, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 26/5/2020. And in the meantime, in trial court, out of 18 charge sheet witnesses, 13 witnesses have been examined. And the evidence of the witnesses are not believable, and in view of the delayed disposal of the trial, the petitioner may be granted bail. Learned counsel for the state, on the other hand, oppose the prayer for bail, praise the evidence of PW4, PW3 and PW4. He further submit that the petitioner has got 3 criminal antecedents, and the accusation against the petitioner is that he assaulted the deceased by means of a tangia, and the deceased has sustained as many as 6 external injuries, and the cause of death was on account of craniocerebral injury. Considering the submission made by the learned counsel for the respective parties in view of the available materials on record, while not inclining to release the petitioner on bail, in view of the period of detention of the petitioner in judicial custody and the progress of the trial so far, I direct the learned trial court to expedite the trial and conclude the same within a period of 3 months from the date of receipt of the order. Petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period.
Lordship, item 16, Lordship, I prefer the adjournment.
Yes. 16 you want adjournment?
Adjournment, Lordship.
Notice sufficient. Item 16.
Yes, Mullah.
All right. Learned counsel for the state submits the notice on the informant is sufficient. It is item number 16. Huh? Learned counsel for the, and he has received also the case diary. Learned counsel for the appellant 6 for an adjournment. Adjourn. Yes, next.
How
Item number 14.
My lord, item number 14, adjourn next week on behalf of S.K.SAHOO.
Mr. Nanda?
May I permit to conduct through VC minute?
Yes, sir.
Lord, this is the second round journey of the petitioner before your lordship. In the last occasion, your lordship
Yes.
In the last occasion, your lordship wanted to know that whether the victim has been examined. The meantime, victim has been examined. I have also given the certified copy of that deposition.
Victim is PW1, Jenna.
Yes, ma'am. Bhatra. Yes.
Yes, Mr. Tripathi.
Yes, ma'am.
This victim girl filed a 490T case.
Yes, ma'am.
Against this present appellant. And that wherein she has mentioned that the appellant is her husband and tortured her. Now, what is the question of this 376?
In that case, my lord, he has been acquitted from the charges.
And you are in custody since when?
No, the petitioner 21/6/2022.
The Learning Council for the state submit that notice on the informant has been made sufficient, non appears for the informant. Considering the submission made by the Learning Council for the appellant, that the appellant is in judicial custody since 21/6/2022, and the victim has already been examined in the trial court as PW1. And after going through the evidence of the victim placed by the Learning Council for the state, I am inclined to release the petitioner on bail allowed. Yes.
Obliged.
Item 14 interim order continue.
Which one?
Item 14 रे interim order continue करो.
Status report करको.
That interim order was not there on the when the last date 9/10/2023 when the matter was taken off. That interim order was not extended. Earlier the interim order was there, but that was not extended. On that day also nobody appeared. So let the report come, we'll see that. Yes, next.
Item 17.
May I please, Your Worship? Offender 395, 307, 294 and 20B and SC/ST Act, my lord. The last time your lordship directed to file an affidavit for criminal act. In the meantime, I have filed an affidavit, and in all cases, the petitioner appellant has granted bail. And in this present case, all the accused person is granted bail by London trial court.
You have got 7 criminal antecedents.
Yes, my lord.
So?
In the case are of 2017 and 18, my lord, and 22.
So where is your comprehensive affidavit?
I have filed, my lord.
Where is that?
In all cases, the petitioner is granted bail. In one case, This honorable court granted bail, but due to this case, he is not released on bail.
302.
302. In that case,
The case is 30 under 302.
in that
Which
case,
one? The earlier case?
Earlier case.
Yes,
in that
Burla PS case number 268 of 2019. It's a 302 case.
Yes, in this case, this honorable court granted bail, man.
So what? After being released on bail, you are misutilizing your liberty.
No, after
This is a case of the
19.
302 case is of year 2019.
19,
So
but
you are
this-
granted bail. Now thereafter you are committing this offense.
in-
This incident took place on 18/10/2022. The FIR was lodged.
yeah,
16/10/2022.
Yes.
And it's a 395 case.
395.
395,
That
307.
known person, they have taken the mobile phone and 10,000 rupees, my lord. The known person,
Your name is not there in the FIR.
no, my name is there, my lord, but other Rinku.
This is item number 17. अब पूर्व जोटा होतला हेडा केते नंबर 15. हाँ 15. All right. Rinku Maji name is there very much.
Yes, madam. The main accused in this case,
so and so ଯୁବକ ମିଶି
this is Sujal Swai
10,000 ଟଙ୍କା so and so ଉଦ୍ଦେଶ୍ୟ ରଖି ଏଇ ଆକ୍ରମଣ କଲେ ମୋ ପୁଅକୁ so and so. Now, what is the status of this case?
2 witnesses have been examined, madam. As per my instruction.
Informant has been examined. And that...
Informant is the father of the victim.
No, that Tanmaya Banchor, who is the victim in this case, ମୋର ପୁଅ Tanmaya Banchorକୁ ଏଇ ମାନେ ୟା କଲେ. Has he been examined?
I have no instruction.
Then you renew after that witness is examined.
I have to take instruction next week. Whether the
Learned
has been
counsel
examined or
for
not.
the appellant seeks for an adjournment to obtain instruction as to whether Tanmaya Banchor, alias Tulu, the son of the informant, has been examined in the trial court or not. Court of this matter give a date. Yes.
Item 18.
May I please, your lordship? May I please, your lordship?
Yes.
Lord, on last occasion, the petitioner was directed to file deposition copies. Deposition copies of PW 1 to 7 has been filed.
You have filed the deposition copy?
Yes, my lord. 7 witnesses. Of 7 witnesses.
So, notice sufficient on
Yes, my lord. Okay, Shagar. PW2 is eyewitness mother.
PW2 is the eyewitness mother. Victim.
So you are in custody since when?
Uh, 26/5/22.
Charge sheet under section 376/511.
Yes,
32BA. SC/ST Act. Okay. Where is the deposition copy you have PW2 काहु कहले किए कोन
PW2.
PW2 Champa Tudu.
Yes, ma'am. Victim is a mentally disabled.
All right, I know the accused so and so. To preserve the relevant, my daughter was present at home. I had been to nearby shop. Stated my daughter was suffering from mental disability. She was in class 9. The arrival I found yes, what about the CA, criminal antecedent?
That is not.
Any medical examination report?
Yeah.
Medical examination has not been done. Victim has denied.
Not examined, sir.
Not examined. No, denied for medical examination. That is in page 38.
Yes.
Patient denied for medical examination.
Victim was also examined.
She did not tell anything because
Unable to.
unable to certify that the victim is unable to tell the matter. She is repeatedly the question asked by me, and the statement of the victim cannot be recorded due to her mental incapacity. So now the main witness is that mother who had seen this. All right, had is Kushbu Panigrahi and Kumar Kashyap, learned counsel appearing through the virtual High Court, Baleshwar, submit that the appellant is in judicial custody since 26/5/2022 and has been charge sheeted under section 376 by 511 of the Indian Penal Code 32BA of the SC/ST Act. It is further submitted that the victim 164 CRPC statement could not be recorded as the London trial court, the London court observed that she was not. Kahin se statement akodala? Se jo 164 statement है. Case kete number 164 ta? Right. The mental, the London JMFC. Which JMFC it is?
Jaleswar.
Jaleswar observed that due to mental incapacity, the victim's statement could not be recorded. The victim also refused for her medical examination. And the star witness on behalf of the prosecution is the mother of the victim, who has already been examined as PW2, and at this stage there is no chance of tampering with the evidence, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and praised the evidence of PW2. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner appellant in judicial custody, the progress of the trial, absence of any material on record to show that the appellant has got any criminal antecedent. I am inclined to release the appellant on bail subject to condition that he shall appear before the learned trial court on each date when the case should be posted for trial, shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Yes. One is Khushbu Panigrahi, the other is Kumar Kashyap. That is there in the cause list. Yes.
Item 19.
May I please, Your Lordship? By the present of
Item 20.
Yes, Mr. Jena.
May I please, your lordship? Last occasion, my lord have given a direction to produce the certified copy of two witness, my lord, namely Joy Krishna Patra and Lipun Patra, my lord, as PW12 and PW13. Certified copy of the.
Have you given the copy?
Yes, my lord.
What they have stated against you?
नहीं 11 जाएंगे देखो 12
They supported the prosecution case.
Yes, Lord.
Informant is my elder brother. Deceased Vijay Patra is my father. Incident happened in so. I had gone with my father to the shop of so. We returned from the shop after purchasing so. At that time, Kunjo-sawa and his wife obstructed us. Kunjo-sawa was holding tangia. His wife was holding a stick. Then they chased to my father for killing. S.K.SAHOO, with holding a tangia, came from his house, chased my father. S.K. threw stones. S.K. threw stones to my father. After they captured my father, S.K. and Kunjo beat my father. I raised holla for my mother. Then Sibo and Hrusikesh is the appellant, dealt tangia blows on my father and then fled away.
PW5 also eyewitness present.
ଏଇଟା ତା ପାଖରେ ଥିଲା ତ ବାପା ସାଙ୍ଗରେ ଯାଇଥିଲା
ତାପରେ ଦୌଡ଼ିକି ତା ମା ଆସିଲା କୁନ୍ତଳା ପାତ୍ର she has seen the occurrence.
So what are the blows that has been given to the 13 ମଧ୍ୟ ସେୟା କହୁଛି?
Yes.
Lipun Patra. Axe blow given to my father. And also to the mother. And she was admitted in the hospital.
That said Kuntala Patra, PW5 Miller, he sustained 2 grievous injury.
Kuntala is PW5?
Yes.
And what about the Vijay Patra, the deceased? Since when you are in custody?
27/6/2017 my lord. 27/6/2017.
2017?
ଆଜ୍ଞା 6.5 ବର୍ଷ ରହିଲା।
ଆଉ ଯାଇନାହାନ୍ତି ବେଲ୍ ଭିତରେ?
ଆଲିର ଆସିଥିଲି ଗୋଟେ ସିଆରଏଲ ରେ ସେଟା 3 ମାସ ପାଇଁ ଯାଇଥିଲି।
କାହିଁ ସେଟା?
ଆନେସର 2 ମିଲର କାଇଣ୍ଡଲି ସେଟା ଆନେସର 2 ମିଲର ପେଜ 14 to 16।
ଠିକ ସମୟରେ ସରେଣ୍ଡର କରିଥିଲେ? ତ 27/6/2017 ମାନେ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର 6.5 ବର୍ଷରୁ 3 ମାସ ଯଦି ବି କଟିଯାଏ 6 years 3 months ହଉଛି।
ବର୍ତ୍ତମାନ 6 ବର୍ଷ 8 ମାସ ହେଇଯାଉଛି କଷ୍ଟଡି। 3 ବର୍ଷ 6 ବର୍ଷ 5 ମାସ।
6 ବର୍ଷ 5 ମାସ। So anything on record that when he was released on interim bail, misutilized the liberty, any such are the learned counsel for the petitioner, learned counsel for the state? Notice sufficient?
Yes, sir.
Learned counsel for the state submitted that notice on the informant sufficient, non-obvious for the informant. Learned counsel for the appellant has produced the deposition copies of Jayakrishna Patra and Lipun Patra, who have been examined in the trial court as PW 12 and PW 13, and they have supported the prosecution case. The deposition copies are taken on record. And counsel submits that the petitioner was taken into judicial custody on 27/6/2017, and taking into account the delay in disposal of the trial, as per the order dated 10/10/2022, passed in CRLA number 382 of 2022, he was granted interim bail for a period of 3 months, and after availing the same, he surrendered at right time in the trial court, and he has never misutilized his liberty. He further submits that when the material witnesses have already been examined, and at this stage there is no chance of tampering with the evidence, and there is also no chance of absconding, the bail application may be favorably considered. Learned counsel for the state, on verification of the case record, submits that there is nothing adverse against the petitioner appellant to have misutilized his liberty while on interim bail. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the progress of the trial, and the conduct of the petitioner in complying with the earlier order of interim bail, I am inclined to release the petitioner on bail allowed.
Okay.
$21.
Mr. Sushant Kumar Rao. Not there. Notice sufficient, Mr.
Yes, Madam.
And you have received the case diary.
Yes.
307 case. How many injured are there?
One.
What is his name?
Name is Prakash Sethi.
What injury he has sustained?
ହାତରେ ଖଣ୍ଡା ଚୋଟ ବାଜିଛି, ଗଭୀର କ୍ଷତ ହେଇଛି.
Injury report
And
ଦେଖନ୍ତୁ.
injury is simple. Simple injury.
କୁଆଡେ ଗଲେ counsel କୁଆଡେ ଗଲେ? Pass over କର. Yes.
Item 22.
Yes, Mr. Ponda. Case diary ଅଛି?
Yes, there is.
Notice of
sufficient.
notice sufficient?
Yes.
Pass over then.
Item 23.
May I please, Mr.
Yes, Mr. Rauta.
Madam, this notice has gone to the matter informant.
Notice?
13/12/23.
Wait. CD available?
Yes.
Did
First application earlier is
first application.
date of custody?
12/12/2015.
Interim bele ଯାଇଥିଲେ?
No, my lord, first time test. And more than 8 years in custody, my lord, status report is called for. It is at flag, my lord. Flag B, my lord, that is.
Flag D कौन कौन?
Flag B, my lord. The status report is
item
called.
number 23. CRLA 995. Flag BS. Charge was framed on 36/2016.
My lord.
Out of 28 charge sheet witnesses, 23 have been examined.
Yes, my lord.
Case was posted to 9/11/23. No PWs. PO is on leave. Case was urgent to so and so. Summons were issued.
And last witness examined on 15th December 2021, my lord.
And what is the offense here?
302 and
302. 302?
302 millet and 32 is stack millet.
One deceased.
One deceased millet. Yes, one deceased.
Any CA?
That has not come.
Review the status report submitted by the London Trial Court, which indicates that the London Counsel for the petitioner submit that the petitioner is in judicial custody since 12/12/2015. Stop. Review the status report submitted by the London Trial Court, which indicates that the charge was framed on 30/8/2016, and out of 28 charge sheet witnesses, 23 witnesses have been examined, and summons have been issued to the rest of the witnesses for their attendance. Land Council submits that in view of the delayed disposal of the trial, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail and submitted that the petitioner has been charge sheeted under Section 302 of the Indian Penal Code and Section 3 of the SC/ST POA Act. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, I am inclined to release the petitioner on bail allowed.
Published.
Item 24.
Yes, Mr.
Chief,
We are appearing for the
I'm appearing for the
Item 28.
May I please, my lord? I am in VC from Sambalpur.
Yes.
I have filed this appeal against the order passed by the learned first additional session of Sambalpur relating to special year case number 1-21 of 2023. Offense alleged in this case is 147, 148, 323, 326, 302, 307, 153A of 506, 149 IPC reading section 3 of SC and SC POA.
What about the service of notice?
No, it just comes for the first time, my lord.
Oh, first time.
Last time
Last
they
time,
directed to
some
remove.
defect. It has
Last
already been removed.
They were directed to remove the defects, my lord.
It has already been removed here. my lord.
Several defects were pointed out. You have removed the defect.
Yes, madam.
Okay, let us see that. Anish Sharma is removed. Right. That is over. So now you have to.
Lordship.
What about the notice?
I'll get the instruction, my lord.
You have already sent the notice for.
No, we have not yet sent any letter, my lord. So send
Because
it to
the last time it was a first.
Lordship.
It came. There was no such that you will survey.
My lord.
You are not required. You are sending that scanned copy to the concerned police station.
Lordship.
All right. Let him. The learned counsel for the appellant submitted Mr. S. Mahanti, learned counsel, appearing through virtual High Court Sambalpur, submits that he has already removed the defects as pointed out by the stamp reporter. Since one of the offense involved in the case is Section 3 of the SC/ST Act, let the learned counsel for the state send the copy of the application to the inspector in charge of Sambalpur Town Police Station for its service in connection with Sambalpur Town PS case number 124 dated 14/4/2023. Put up this matter in the week commencing from 19th of February 2024. The Land Council for the state shall produce the case diary, obtain instruction about the criminal antecedent, if any, against the appellant. So also get the confirmation letter regarding service of notice on the informant. Put up, yes, give a free copy of the order to the London State Council. So it will come on 19th of February 2024.
Lordship.
Obliged.
Item 29.
May I please? My lord, I filed an IA for interim bail, my lord. Here in this case, my lord, petitioner has been charge sheeted.
By interim bail on what grounds?
My lord, the wife of the petitioner is ill, my lord. And the petitioner is in custody since 10/11/2022.
You have filed some medical documents.
Yes, my lord.
You are appearing for the informant. Have you been served with the copy of the interim application?
No, sir.
Give a, and what is your instruction about the IA?
My lords, they have served us a copy on 12th January, Lordship.
You have not yet obtained.
Not yet obtained.
Get the instruction.
I will get the instruction.
Next week.
Give a service.
I'll give it by tomorrow.
IA number.
Appeal, Lordship.
Appeal memo is there.
No, 18
All right. IA number 94 of 2024. This is an application for interim bail on the ground of ailment of the wife of the appellant. Let a copy of the appeal memo along with the interim application be served on the Land Council for the informant. Land Council for the state seeks some time to obtain instruction on the interim application. Put up this matter. Era court Baleswar. Coming week re heiପାରିବ?
My lords, I'll
All right,
take that.
put up this matter in the week commencing from 12th February 2024. Yes.
Obliged.
Item 30.
That's a pursuant to the order dated 20th/11/2023, have served
Item 31.
my lord, notice extra copies are my lord. And
कौन है notice को था?
Yes, notice has been made sufficient.
केबे?
My lords, the date is actually not there, but she has signed on a copy of the CRL.
So let go 1 week time is to be granted. So that
Actually, the date is not mentioned, my lords. She has a CD we have received on 22/1, my lords. The case diary,
22/1.
my lords.
So is it your first application?
first application.
What is the custody date?
18/8/2023.
What are the offenses under which charge sheet
Offense, my
submitted?
lord, charge sheet, my lord, is not with me, but the
Yes,
in the
Mr. Mishra.
Lords, section 417,
yes,
493, 323 of the IPC, read with section 31W I, along with 2V of the SC/ST POA Act.
2 VA,
2 VA.
my lord.
Okay, what is the age of the victim?
Age, my lord, 20 years. As per the FIR.
164 achhi
20 years, my lords.
Huh?
20 years, my lords.
Victim,
As per the 164 statement. Lords.
The love affair then went to Bangalore, stayed there,
my lord.
kept physical relationship. Any criminal antecedents?
Lords, nothing adverse against. Except
The
this.
learned counsel for the petition, learned counsel for the state. Learned counsel for the state submits that notice on the respondent number 2 has been made sufficient. Non appears for the respondent number 2. Considering the submission made by the learned counsel for the appellant that the appellant is in judicial custody since 18/8/2023. He has been charge sheeted under section 417, 493, 323 of the IPC, section 31WI oblique 32VA of the SC/ST Act. And after going through the 164 CRPC statement of the victim, which is aged about 20 years, stated about her love affair with the appellant and going to Bangalore with him, staying in a rented house, keeping physical relationship, and absence of any criminal antecedent against the appellant as stated by the learned counsel for the state. I am inclined to release the appellant on bail allowed.
Bless.
Item 32.
May I please, your lords? Appellant is
33.
Might please, Your Lordship. The allegation is that on 13/7/2011,
Bail matter,
bail matter,
notice sufficient.
they were to take they were to take instruction because on the alleged date the petitioner was in Surat jail. I have given papers.
Has already been sent to so and so by BLA field number. Said record sent requisition to the jail super. Last person to verify the status of this. Until date the same is not received. That is the instruction.
I pray for tomorrow, my lords, because I've communicated today itself. They are in
Contact
communication with the superintendent of that jail to ascertain whether he was in fact in custody at that period of time. I'll get instruction on the notice tomorrow as well.
Surat jail from
No,
4/6
when the date of occurrence according to your
13/7/2011,
it's on a particular date.
13/7/11, and the period during which he was in Surat jail is 4/6/2011 to 16/7/2011. That means on 13/7/2011.
So it's a case under section 302.
My lord, several offences are there. Your Lordship.
And the allegation against you is whether participation or conspiracy
No,
part.
just presence.
Present.
2,000 people came there because there was bad blood between two villages. The allegation is that 2,000 people came, they assaulted the informant's husband, and he was killed.
You have taken that specific stand in the bail application.
My lord.
Where is that?
My stand is that.
No, your stand plea of alibi is to be, if you are taking, you should take it specifically.
I have filed affidavit.
Where is that?
Subsequently, yes, that was the Lordship directed on the previous.
Onus lies on you to prove it.
Yes, my lord.
And that too beyond all reasonable doubt.
I have submitted, my lord. But in an affidavit, I have submitted that he was in jail. I have submitted the certificate granted by the Surat jail authorities. That is why your Lordship directed them to take instruction on that issue.
So, get it tomorrow we'll take up this matter. এটা ରଖିଥାନ୍ତୁ କାଲିକି ଏଟା ନେଇ ଆସିବେ list ରେ ନା please this matter tomorrow ପର୍ଯ୍ୟନ୍ତ as prayed for by the learned council for this. Yes.
Item 33.
Yes, Mr. Panda.
Here, 34.
34.
That's right. Please, Your Lordship.
34.
Lords, here your Lordship was pleased to call for a status report, and notice has also been issued to the.
So and so copies of charge sheet submitted, and out of 40 witnesses, 3 witnesses have been examined, including victim, informant, and declined 4 witnesses. So. Victim has been examined?
Yes, victim has been examined. Her parents have been examined. I have annexed the copies of 1 and 2. And so far as 3 is concerned, this is the copy. That is the mother. Your Lordship may look at the victim statement. That's at page 16 of the brief. Paragraph 2, she has stated that the alleged incident occurred on 10th November 2022.
What is the offense under which charge sheet submitted?
Charge sheet, my lords, is under sections 363, 376(3), 376(2)(n), 506 IPC, 6 POCSO Act, 31R, 32V, and 32VA of the SC and ST. Paragraph 1 I have stated.
So, in the chief examination, the victim stated that the accused kept physical relationship with her.
Yes.
So she has not stated anything to attract the ingrate.